I'm looking all over my screen trying to figure out how to record. There was a button that said record. That would have been very easy for me. So, um, with me this morning, Jamie Olin. Jamie, do you want to give yourself an introduction before we start?
Sure. Good morning, everyone. Like Jessica said, it's so cool to see people from all over the state. And I think this gets just more and more expansive every year. I've been judging mock trial and on the mock trial committee probably for about the last dozen years or so. So it's always really fun to do this clinic and see the variety of people who have done this before and are sort of old pros. Jessica and I were talking before that some of y'all know the rules of evidence better than we do. And so that's always really cool to see every year. And then people who are just starting out and are going to be the pros in a year or two. And it's just great to be able to meet everybody now.
Yeah, thanks, Jamie. Kevin, I know you're here hiding a little bit. Do you want to give yourself an introduction also?
Yeah, so my name is Kevin Anders. I'm an attorney here in the Metroplex. It's I've been with the committee for the last probably 8 9 years now, and have been judging and helping do some of the facilitating of scoring and pairing judging and things like that. And it's great to see uh, y'all come out on a beautiful Saturday morning in November when there's a lot of other things going on, um, for you to learn for something that I didn't really have the opportunity to do when I was in high school. So this is great.
Yeah, and I didn't quite remember to introduce myself. My name is Jessica Alexander, and with Jamie and Kevin, we're all co-chairs of the Dallas Bar Association's Mock Trial Committee. We are the state committee, our kind of like also the technical guidance committee, as you will. So we write the problem, we run competitions, and we're kind of the people who update the rules and do kind of all the things to help it run across the state. You will all have local coordinators who are doing the Lord's work and setting up your local competition. So please, give them love and respect and assistance when you can, because it is such a hard job running those local competitions. If you're here from Houston, shout out. Kevin and I will see you in February because we help run the Houston competition as well. And yeah, so that's kind of what we do to help run these competitions. And then obviously we're here kind of running a little clinic for you guys, which we're very excited about. We started doing this during COVID and we got such an amazing response and so many people participating across the state that Jamie and I were just like, we're running this competition. We're going to run this clinic, not the competition. We're going to run this clinic, until we can't anymore, basically. So as long as we keep getting buy-in from you guys, we can keep telling them, hey, we got to run another virtual clinic because we had people from El Paso, people from McAllen, people from FAR, people from Corpus Christi, from Lubbock. Like it's so worth it to see so much participation statewide, and we're so excited to be able to bring this to you to give you all a little bit of guidance, a little bit of tips, and to answer any questions you have up front. Um, so our format this year is going to be a little bit different just because, candidly, being an attorney sometimes means that we don't have full control over our schedules and when we're going to be super busy. And I think all of us at the same time um, have just been kind of at capacity with our normal attorney work. And so instead of doing breakout rooms this year, we're going to just do one session for everybody. We're going to try to make it really fulfilling for the students who have done this before. But we're going to start with some really beginner level stuff because we do have a lot of beginners here today. So we're going to start with the basics and then we're going to leave room for some higher level feedbacks, participation, and obviously questions. And so if you have questions, if there's anything you're concerned about, just throw it in the chat. You can also message Kevin. I'm going to put you in charge of chat stuff if that's okay with you. Um, you can message Kevin directly if you're just like, I have a really dumb question and I don't want anybody to know that it was me asking it. First of all, I promise there are no dumb questions. We don't feel that way. We want to answer every question you have, but if you just really you don't want your name attached to it, just put it in a message to Kevin. Hold on one second while I yell at my child, please. Get out of here. Okay. Yeah, he's not responding very well today. It's very helpful. Um,
Sounds like he's in his 20s.
no, he's 10. He's very 10. Um, so between him and the dog, it's kind of becoming a little bit chaotic. So I'm so sorry about that. But yeah, so that's kind of what we're going to do this morning. We're just going to be all one big happy family together. We're not going to break out. We're not going to do separate sessions. Um, and then, yeah, so that's where we're going to start. So as always, we're going to start with some rules information, particularly because this year we do have some new rules. We've changed some of the rules slightly. And so I wanted to be able to give a highlight to those for you guys. Um, oh, oh my gosh. Um, just sheer chaos. This is matched only by when we were trying to run a virtual competition a couple years ago, and the children were literally rustling behind me as I was trying to like facilitate a competition on Zoom. So, I apologize for the chaos in my house this morning. So, we're gonna do the rules first, the rules breakdown. We're gonna give you some information, and like, there's absolutely please ask questions if you have any concerns. So, I have kind of taken on the role of being kind of the rules person the last few years. So when you see rules updates, that's me. So if you hate them, you could just keep it to yourself. If you love them, you can definitely tell me how much you love the work I did. Um, but if you ever have questions or concerns about a rule, like you just don't understand it, please feel free to send those to Melissa so that she can get you clarification. So this year, part of the changes we made was to kind of facilitate or to correct provide clarity to some questions we kept getting over and over and over. So, um, as always, I kind of start with team composition because we've got a lot of new teams here. A team consists of at least 6, no more than 10 members. We're going to have attorneys, witnesses, timekeepers. And to be clear, there's wiggle room on that. You can have alternate team members, you can have extra people, um, but you can only put so many people on your roster for the competition day. So any 6 of your 10 official team members participate in a given round as attorneys and witnesses. And then you're also going to have a timekeeper. Most importantly, there's going to be a roster to fill out every single competition day. Please fill them out correctly because um, most competitions give prizes for best advocate and best witness. And so if you're not putting names in correctly, you may not get the awards that you were otherwise entitled to. So um, I just saw a question pop up about recording. Yes, I think I said it kind of before we started. We are recording, and yes, this recording will be made available to everybody, so nobody needs to separately record. So please don't worry about that. Um, so one of the things we kind of also will do in pretrial introductions more often than not is we will ask people to introduce themselves to make sure your roster is correct. So we just that's kind of the basic composition. So you're going to have 3 attorneys, you're going to have 3 witnesses. Each of your 3 attorneys are going to do one direct examination and one cross-examination. In addition, you're going to have an attorney who does the opening and an attorney who does the closing. Those will be different attorneys. So one of the things we ran into last year is, the flu really tried to wipe out, I think, literally everybody one weekend who was trying to participate. And so in an effort to allow teams to participate, we did let students kind of repeat roles within their trials and to kind of make it fair to the other teams. Basically, the attorney who did 2 directs, for example, they got a score for their first one and no score for their second one. So we will make accommodations to let people compete because that's really our first and foremost goal is we want as many students to compete as possible. Now, those were special exceptions we made because, like I said, I think half the teams who participated from Dallas ISD last year, for example, came down with the flu or COVID or both. So it was a very dramatic kind of competition day for them in terms of how many people weren't able to come and how many people weren't able to participate. So I don't know that I have a slide specifically about accommodations, but we will always try to make reasonable accommodations for really any need that a team has, but we may also offset that to make it fair and balanced for other teams. And so in this case, like I said, we let students kind of repeat skills that they're not technically supposed to. And so we offset that by reducing their ability to get points for repeating over and over again. So I'm saying that because I don't want anyone to think that you're going to be allowed to just take your best attorney and let them do three directs and carry you through the competition. That's otherwise not allowed. It was a special exception we made because of the illnesses that were kind of wiping out teams. So again, we have three people who are going to be three witnesses. One person cannot be multiple witnesses. One of the things that sometimes is a little confusing is that when an attorney is doing the direct examination of a witness, they are the only person who can make objections. And so that is both, they're also the only person who can cross-examine, or if they start cross-examining a witness, they're the only person who can make objections during the direct of that witness. So it's one attorney, one witness rule. So they're buddies, and the other people can't kind of stand up and object. Now, um, we'll kind of get to that rule clarification in a second, but obviously your teammate can go like, hey, you should object, or like point to your list of objections or whatever. That's not interference with this rule. That doesn't bring this rule into question. What we're saying is that the only person who can stand up and address the court during a witness is the attorney assigned to that witness. Okay. So we've got some basic rules. Our problem consists of three witnesses per side. They all have names. They can be played by female or male presenting students or non-binary students. It does not matter to us. There's no specific rules about gender or anything like that. All three witnesses per side must be called, and a team may not call any of their own witnesses as a hostile witness. That means you don't, if on side A, the plaintiff, you have the plaintiff themselves. You can't call the plaintiff to the stand and be like, they're a hostile witness, I'm going to cross-examine them. First of all, that wouldn't make sense, but as an example, your three witnesses on your side are your witnesses. You don't get the opportunity to kind of flip them so that you can do cross-exam or anything of that nature, things that we might, as attorneys, do in real life sometimes. Let's see. We have a trial sequence with really strict time limits, and the timekeepers kind of keep this information going. These are maximum times. You don't have to meet your maximum time. You don't have to use the entire time. So if your direct only takes 20 minutes, great. You do not, however, get that 5 extra minutes in another section of the trial. So time remaining in one segment does not transfer, and you can't change the order of the trial, for any reason. And as far as directs, redirects, all of that, we limit it to one redirect and one recross. That's rule 4.22, and we don't get more than that. And the reason is because you could probably redirect and recross forever if you had the opportunity to do so. But to make sure the trials actually end, we do put a limit on how many of those you can do. Okay, and then independent research relating to the case topic, generally speaking, you could do all the independent research you want to do to better understand the facts, the rules of evidence, whatever. However, you cannot present any of that into the trial itself. So, and an example would be if you researched the difference between music and lyrics or details about a songwriting process, that's fine if you're just trying to understand it, but you don't get to have a witness testify to that information unless it's in their fact pattern. So feel free to watch YouTube videos, read articles, parse the rules about hearsay, and like do all the things we as attorneys sometimes do, where we have to do a deep dive on like, what is this esoteric rule about? What is this case law really about? But in mock trial, you don't get to cite to that research or case anytime you like if you make an objection or you have to respond to something, you don't get to say, oh, well, according to so and so's article about XYZ, right? Okay. And then finally, should any independent research suggest or prove that a fact contained in our case materials is incorrect or inaccurate, the case materials control. So, um, if materials say the sky was pink, but your research and your scientific knowledge tell you the sky can never be pink, um, witnesses maybe disagree as to the color of the sky that particular day, but nobody can testify as to like the scientific principles underpinning your belief that it could not possibly have been pink. Okay. Because if the case materials, the witness says it was pink, that's what that witness has to testify to. And you can't attack that witness based on outside research regarding the science behind it. Okay, and then objections. We do have some specific objections spelled out for you in the rules in 4.19, but I highlight this just to tell you that this is not an exhaustive list of objections that may be made. Any objection consistent with the competition's rules of evidence is allowed. So I don't want you to think that like, oh, I can't make an objection because it wasn't in 4.19. As long as it was in the rules of evidence, you can still make that objection. Okay, I'm going to pause briefly right there. If anybody has questions, Kevin, if you've seen any questions about the rules I've covered so far, I want to give a chance to.
Yeah. Yes, just got a good question. So, can independent research such as quotes or general information be included in the opening/closing statement?
So, I would say a quote, a famous quote of some sort can be used in an opening. Jamie, you can tell me if you disagree with this, but you can definitely reference like Maya Angelou once said, da 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 da. That's allowed. That's totally fine. What we can't do is have a witness use a quote by somebody else to prove or disprove facts of the case. So that's what's not going to be permitted, is the kind of what the distinction I would draw there is. Was there any other questions in the chat or anything else that we want to talk about before
Nope.
we? Okay, so I'm going to move into the things that we've updated this year. So I have it labeled as new rules. Technically, most of these are just clarifications for you guys, okay? And again, I did this just to make sure we were basically what we do is we keep track of like what kind of questions we get from people as we go. And there were a couple of things we kept getting questions about. And so we really made a point to kind of provide clarity for some of these things. So, first and foremost, for timekeeping, the rules have changed. Students must use stopwatches for timekeeping. We've been running into a little bit of an issue with some use of cell phones, and we really try to prohibit cell phones or other devices. To be clear, if you need an accommodation for this, you talk to your local competition coordinator and talk to them about the reasons you can't use a stopwatch. And they're free to make those decisions locally. We're not going to get involved with that. And then obviously when I say we're not allowed to use cell phones, they are of course going to be permitted as a medical device. So if anybody has diabetes and uses their cell phone to track their blood sugar, for example, that will be permitted. You just want to kind of give a heads up to the judges and let them know that like we're going to have a cell phone, but we're not using it. It's there literally just to be a medical alert kind of system. Okay, so the only other kind of timekeeping updates we made is it was previously Rule 1.4, but we moved it to 3.5 regarding general timekeeper duties because it just didn't make sense to have it kind of in the introduction to the rules. So we just moved it to where it made sense. So if you're like, hey, that rule went away, no, it didn't, it just got moved. And then we used to reference a timekeeper orientation that never took place. So we have removed the reference to a timekeeper orientation. So hopefully we won't get questions about when that's happening this year. There is no timekeeper orientation.
If I can just weigh in on one thing that Jessica said, Some of you might be wondering, how do I ask the presiding judge for an accommodation of some sort? Like, when's the right time to do that, and how do I do that? And as somebody who's the presiding judge a lot in these mock trials, as are Jessica and Kevin, there's dead time at the beginning when everyone's getting situated and the jurors are getting situated. And that's the perfect time for the student or your coach to just come up to the bar and talk to the presiding judge and say, hey, we have a student who's diabetic who needs to use their device for tracking their blood sugar or whatever the case is. And we're always going to say, okay, thanks for letting us know. But that's a great time to do it, is in that dead time before the trial actually starts.
100% agree. And normally coaches, we don't really want coaches involved in conversations because it's really the student run competition, but that is going to be an exception, obviously. So a student doesn't feel like they have to have that conversation. A coach is absolutely allowed to come up and say, like, hey, this is what's going on. Can we get an accommodation or get an exception or whatever you need? So yeah, and so I think the other thing that has come up several times in the past is we do get notified, hey, we have a student in a wheelchair. They obviously can't stand to make objections. We can see that with our eyes. We're not going to hold that against a student, but like absolutely, please let us know because sometimes if they're behind a table, like say you're starting on the defense and you're behind the table, I actually may not be able to see that there's a wheelchair going on. So it is nice to kind of give us a heads up that like, hey, he's in a wheelchair. And we're like, oh, okay, great. Like, that's fine. We don't need a whole lot of information. We don't need to know. We don't have to know your diagnoses or anything like that. To be clear, you are not required to tell us that. So if just there's something that's going to impede your ability to do what normally is expected in the trial, the coach or the student or whoever can come up and talk to the presiding judge and just give a heads up, and that's totally fine. Um, okay, so um, we have amended Rule 411. Whiteboards, pen boards are no longer permitted for any reason. This is a clarification of our previous rule, which did allow it, but it was also very misunderstood. And there was always a lot of confusion over what exactly is allowed, what exactly is not allowed. And so in an effort to kind of promote fairness for all teams, particularly those without resources to buy whiteboards or pen boards, they are now just prohibited. So if you previously used them to display exhibits and your question is, how do I display an exhibit? The answer is you hold it up with your hands. That's the answer. Um, and again, if a student has something that's going to prevent them from themselves holding it up, you can ask for that accommodation beforehand. Like, hey, he's in a cast. He literally can't hold up the exhibit. A teammate can hold up the exhibit for him. In that case, we would let that happen. But so we're just eliminating whiteboards, eliminating pen boards because I think pretty much across the state, every single time we had one appear last year, it led to a little bit of a panic situation over what is allowed, what is not allowed. So we've just they're no longer allowed. Please don't bring them to the courthouse. Unless you're obviously just using it for like between rounds prep, but even then like maybe don't bring it. Would be my suggestion. So um trial communication. This is just a clarification and not a change. The rule is the same, but the rule was written, I think, a little messy. And so we were constantly getting questions about what was allowed and what was not allowed. So we rewrote the rule just to try to make it nice and clean and clear as to like what is allowed. So the six people competing, the three attorneys and the three witnesses, can talk to each other during the round at all times. I mean, you probably shouldn't be talking to each other if the witness is on the stand, but otherwise you can talk to each other. You can pass notes. You can have communication. It is allowed at all times. What was driving some of the confusion was whether or not the witnesses could talk to the attorneys. And the answer is yes. The six people competing can absolutely talk to each other. So we rewrote the rule, hoping for some clarity and to kind of avoid getting that question over and over and over. Because honestly, there was a little bit of confusion among some of our judges as well. We had a couple judges that were like, oh, they were talking to the witness during the round, and I would be like, yeah, they're allowed to do that actually. The person who is not allowed to talk is the timekeeper. The timekeeper may not communicate with any members of the team once the round has started. The only person the timekeeper can communicate with once the round has started is the presiding judge. Um, Jamie, anything to add there?
Yeah, just another note on the timekeeper issue. If you're an attorney who is questioning a witness and you're getting very worried that you're running out of time, the way to deal with that is to ask the presiding judge, can I get a time check? And then the timekeepers will stand up, they'll consult their time, and they'll tell the presiding judge, yes, this side has 1 minute and 30 seconds left. So that's how that works.
Yeah, and I will also say, as a presiding judge, I don't necessarily like stare at the timekeepers, but I do notice if they're not flipping their time cards relatively close to each other. It's kind of like a peripheral vision thing. So I have stopped I said, hey, pause the time. What's going on with your time right now? Um, so if you feel like there's a disparity or a discrepancy, you can also, as an attorney, stand up and ask the court to address that. The timekeepers themselves may also, like, Your Honor, may we pause the time? Yes, because we need to talk about an issue. So I've had that happen as well. So I don't want anyone to think that like the time can just be like crazy, random, and whatever, and no one's going to pay attention. We will address those things. And it's not in this slide, but timekeeping issues are solely within the purview of the presiding judge. If there's an issue, it needs to be brought up at the time there is an issue, because once your round is over and you leave, nobody can fix time issues. No one's going to be able to take it into account. We're not going to be able to adjust points for any reason or whatever. So, if you think a timekeeper is not keeping time correctly, the time to address that is when it's happening. And I will say, as a reminder, if your team does not have a timekeeper, you are stuck with the other team's timekeeping. So if you want the ability to bring up, a disparity in time or issues like that, you're going to have to really have your own timekeeper to be able to do that. But that also helps keep everybody on the same page and keep people accountable. So again, 6 people competing can talk to each other. We're hoping that we rewrite this rule with enough clarity that we won't have the confusion we had last year. So, yeah, go forth and conquer and talk to each other. Again, as long as it's not disruptive or distracting. If you're talking to each other in a way that, like, I, as the judge, can't really hear what's happening with the current, direct of a witness because you guys are shuffling papers and frantically talking to each other and whatever, then I, as the judge, would be like, hey, calm down. Um, or whatever I might say that's slightly more judgy. I don't know. But as long as you're not distracting or disrupting the entire process, you're allowed to talk to each other. Don't worry about it. So,
Yeah, and just one other thing on that, and then I know we have some questions in the chat. Um, like I for one am really terrible at whispering. Like I'll lean over to whisper to someone and then it just comes out in my regular voice. So I don't even try. Like when I am sitting at counsel table in court, I pass notes. And so that's something if you're just starting out in mock trial, bring a pad of post-its and then divide it up between the people at counsel table. And that's usually, in my experience, the best way to communicate with the witnesses, between the attorneys, is just to pass post-its back and forth.
mhm.
But if you're good at whispering, more power to you. But I would not communicate amongst each other in a voice louder than a whisper.
Yeah, and on the flip side of that, I have mild hearing loss, which means if somebody is whispering to me more often than not, I don't understand what they're saying. So then it turns into like I don't what did you say? I actually can't hear you. So and it's hilarious because I turn my bad ear closer to them every single time, just like out of his instinct. So yeah, so pass notes, point to things like that's why I love having, like, for example, objections. If you have like a list of your common objections printed and you have that right there, your teammate can just point at the objection they want you to make. So no one has to talk, no one has to converse back and forth. You can just look and go up, objection hearsay, right? That kind of thing. So, but otherwise, yes, you're allowed to talk to each other. Okay.
Hey,
Yeah.
Jessica,
Yeah.
we got a good question in the chat. So the question is I wonder if is our teams allowed to talk to the people in the jury box? Um, so I guess if you're trying to talk to like the judges who are like part of the scoring, as like you are communicating with them as far as like presenting information, that's one thing. That's pretty normal. But if you're trying to like communicate as in like you have like questions or things like that, that's typically not allowed. Jessica, what are your thoughts? And maybe I could get more clarification.
Yeah, if we get some clarification on what the question is, I think if you're when we say talking to, what I mean is like a conversation. Obviously in your opening, your close, even while the witnesses are talking, they should be directing that at the scoring judges in the jury box as if it was a real jury. That's not really the same as communicating, right? It's just like I'm turning my face this way while I say the things that I'm saying. Um, if you could provide if whoever asked this question could provide some clarity, and obviously like I've seen this happen, hey, like can I have my exhibit back? That is fine. Because sometimes we publish things to the jury and then we realize like we want to talk about that exhibit to the very next witness. Um, that's okay. But generally, I don't know what kind of communication there would be between a team and the jury box otherwise. So if you're the person who asked that question, maybe clarify it to Kevin and we'll get you an answer momentarily. Um, so 4.15 has been updated to allow for some limited recording or video or photographs by some parents or coaches, but it's going to be limited to the person that belongs to them. Because we candidly, if you guys are not 18, you're not allowed to consent to anything. Your parents have to consent on your behalf. We, as the mock trial committee, get consents for video photography, and we may have official photographies and photographers running around rooms or whatever. But if it's like your mom came and she really wants to take a picture of you, she can take a picture of you. Okay. We don't want pictures being taken of everybody everywhere. Coaches, if you get your own separate consents, you're allowed to take pictures if you want to while it's happening. We're not going to get in the way of that, but we don't, we recognize that when the rule was originally written banning these things, it was back in the day where we had these like honking camcorders that had to do the videography kind of situation. And for the children in the chat who may not know, they were like yay big and you had to like put them on your shoulder and it was very disruptive trying to record things. And the only options we had for photography were like bigger cameras, that are maybe more disruptive, louder. But now we have like our little discreet iPhones, so we can just go doop, right? It's not as disruptive. So we recognize that that has changed. Technology has changed. So we're going to allow some limited stuff, but the rules also are going to prohibit you from posting those on social media. If you're taking pictures of somebody else's kid, consider that you shouldn't be doing that. Um, that's really being directed at the adults in the chat less than the children because you guys will be competing, not paying attention to that. So for the adults in the chat, you are permitted to take pictures of your teams, but just please use some common sense on those things. 4.24 was removed. 4.24 allowed for critiques between rounds. We, as a practical matter, have not been doing those, but it was still in the rules. So we have just gone ahead and removed it. We were getting some pushback from one region in particular, and they were like, well, it's allowed in the rules. We love doing critiques. And we kept saying, like, okay, but it takes up a lot of time and we're trying to run these competitions to get everybody in and out. We don't want to waste your time. And then they seem to finally come to realize last year there was like a medical emergency with the team that like really delayed around. So then they were like, "Oh yeah, I guess we don't have time to do critiques." And we were just like, "Yes, obviously we don't have time for it." So we just went ahead and removed the rule. So hopefully nobody will be expecting it. And it's not because we don't love you and don't want to give you feedback. It's just because we also recognize you don't want to be there till 11 o'clock at night if you don't have to. So we've just removed that so we can kind of go through the rounds a little bit quicker and more efficiently. So that is all I have for rules updates. Are there any other questions in the chat about rules?
Yeah, we've gotten a couple of good questions. So, will phones be banned to those in the observation section of students who are not actively participating?
I mean, no. I mean, anybody in the gallery could still have their phone, but again, everything is going to be subject to whether or not it's distracting or disruptive. So, um, I don't know. It's going to be kind of up to what's actually happening. But if a student in the gallery just has their phone, no, they're not going to be in trouble, and we're not going to yell at them for just having a phone.
Yeah. It's the very first thing I say as a presiding judge is to have everyone take out their phone and make sure it's on silent or at least vibrate. And nevertheless, at least once every mock trial season, I'll have somebody in the gallery's phone go off. And this is really because it's not fair to the students who are participating in mock trial to get distracted by somebody's phone going off. I mean, that's the main reason for this. So it's fine to have a phone, but I think all the presiding judges are going to tell you to have the noise turned off.
And I, as presiding judge, have learned that I have to put my phone on Do Not Disturb because if I do not put it on Do Not Disturb, I will inevitably get a spam call in the middle of presiding and I will be very distracted. I will just be like, what is happening on my phone? Um, so I also do recommend that. Put your phone on Do Not Disturb so it's just not even alerting you so you're not getting distracted. But yeah, I think what Jamie said, as long as we're just keeping them on silent, it's not gonna be a problem. Was there something else, Kevin? You said there were a couple questions.
Yes. So as far as one question. So during a civil case, is the plaintiff allowed to sit with the attorneys?
I mean, technically yes, but I will say practically speaking, I've not yet been in a courtroom where there's enough room for four people at the table.
Because because and the flip side of that is, having the defendant sit at the edge of the table, with the defense.
Yeah, I would just say it's not disallowed, but practically speaking, these courtrooms are not that big
Mm-hmm.
that we're going to be in. Jamie, do you have any thoughts about this one?
I think it's fine either way. I don't think it gives any kind of advantage to the team to do that. I think in a criminal case, it's a different matter just emotionally to have the defendant sitting at counsel table with counsel, because it's humanizing and this happens in real life criminal trials all the time. I'm not sure it makes that much of a difference in the civil case, but I certainly wouldn't penalize a team who wanted to do that.
I mean, like in real life, we would put the plaintiff at the plaintiff table, but for the purpose of a mock trial, I it you're not going to get a point or lose a point for it. It's not something we factor in at all. So, because what you get points for is actual witness performance when they're on the stand and actual advocacy, actual things the attorneys are doing when they're presenting their particular points. So, that doesn't give a point or lose a point either way because it's not required. Um, there are certain behaviors that might lose you a point for a rules violation, such as if you're communicating with somebody in the gallery, that would perhaps lose you a point, but having them sit at the table or not sit at the table is not going to actually factor one way or the other. And so, again, it's really going to come down to do you have room for it? Because we've had some courtrooms where there's barely room for the three attorneys at the table. So there's certainly not room for a fourth person. So hopefully that answers that question. Was there anything else in the chat?
No, not no. I think we're good.
Okay. Okay. So moving on to dress code. Really, the rule about the dress code is that there is no dress code. We pull this up every year just to reassure you guys because we get so much panic and so much concern about what is allowed, what is not allowed. There is no dress code. Generally speaking, you just want to be clean and presentable. We don't have any rules about requiring suits or anything of that nature. And we make sure that to tell all of our coordinators and all of our judges that as well. That is not something, again, that you're going to lose or earn points for, with the exception of you cannot wear anything that's branded with your school name. You can't wear a t-shirt that says Plano West High School, for example, or you can't have like your Samuel High School varsity jacket on. You can't and we prefer those not even be in the room because if somebody in the gallery like has their El Paso binder or we can see El Paso High School on it, like, okay, we're going to start to get, okay, now you're telling the judges what school you're from. And generally speaking, like, I know what schools the teams are from because I'm running the competition. Um, Jamie actually, when she comes to competition, she doesn't know. She likes to preside, and so she kind of just is like, I don't know which school's which. So for those of us on the committee, it's not going to affect our scores because like we know who all the schools are. So, but for a judge who has never done it before, you don't want to give them some like you don't want to trigger unconscious bias or anything like that. More than anything, like I'm a product of Rowlett High School. If Rowlett showed up to mock trial this year and I knew it was Rowlett, I'd be like, oh man, I want them to win just because like the soft side of me is just like I want that. But I don't want teams to know, right? If it's a judge who's outside of the committee, I wouldn't judge them, to be very clear, but somebody who's not on the committee who doesn't know, we just don't want them to know who the schools are so that it's fair to everybody, so that everybody is just kind of strangers. And we do have rules for judges that they're supposed to notify us of conflict, so don't worry about that. So that's the only real, I guess the second rule for dress code is no costumes. That's technically a dress code rule. Like a doctor can't dress up in, a white coat and that sort of thing. But otherwise, there's just no dress code. You can just wear what you want. Female presenting students do not have to wear dresses or skirts. I hardly ever wear those to court anyway. Um, and if you do choose to wear a dress or a skirt, you do not have to wear pantyhose. Please do not do not make your grandma guilt you into wearing pantyhose. They're uncomfortable. You don't have to do that. If you want to, by all means, please do it. But if somebody in your life is telling you it's required, it's not required. You can show them this video. You don't have to wear pantyhose. And so then I just have some pictures I've shown a couple times. Jamie, do you have anything before I show them the pictures?
Yeah, I give this disclaimer every year, which is about shoes, which is about do not wear your new pair of cute shoes for the first time when you're coming to mock trial, because all you will be thinking about the entire time is how uncomfortable your new cute shoes are. And I'm telling you this from my own experience. So if you are not comfortable in high heels, don't wear high heels. If your shoes, like I love these shoes, but I just got them on Poshmark, they're half a size too small, don't wear them. Just wear whatever you're comfortable in because you will be moving around the courtroom throughout the course of the trial.
Yeah, 100%. I mean, you can wear them, but you're also gonna at some point have a blister and you're gonna be very
Yeah.
unhappy. I speak from personal experience. I'm seeing questions about audio recordings of that sort of thing. No, we're not. You're generally not allowed to record an entire trial, is going to be the answer to that question. The exception we're making this year is so that because parents in the past have been like, I just want to take a picture of my beautiful child sitting on the witness stand. They can now do that because we can do it in a non-disruptive manner. But we're generally still not allowing like recordings of an entire thing. Okay, so pictures of the dress code. Just see, we got some pants, a little bit of matching ties. I should say pictures of the not dress code is actually what the correct statement was. Okay, so those were just some random pictures from state a couple years ago that I was able to pull. And so you can just see there's a variety of dress options, there's a variety of shoe options. Wear what makes you feel comfortable and confident that you're going to be able to do your very best job in. Um, please don't please don't worry about it. And if you run into a judge who's like, you should have been wearing pantyhose and I took points off for that, please complain to your regional coordinator about that. You should not. Um, I've actually never had a judge. I think this is will be my seventh year running competitions. Maybe. I don't know. I've lost track of time. But Kevin, Jamie, you guys can tell me. I've never seen somebody come back to the room and say they weren't wearing pantyhose. I didn't like what they were wearing. What they have come back and said is they were wearing a costume. And so then we have a conversation about whether or not it really was a costume, whether or not we thought that it applied. Because at least in the competitions that I help run, we always talk to the judges when they're trying to do rules violation points, because we have that section where you can lose points for violating the rules. We always try to have a conversation with them about, okay, why did you deduct the points so that we can make sure those are valid. Um, okay, and so general trial etiquette. I don't know. I don't really have a full slide on this. I just have some notes and then, I'll probably throw it to Jamie. Treat the presiding judge as you would a real judge. Ultimately their rulings are going to stand. You don't want to stand there and keep arguing with the presiding judge. You're probably just wasting your time doing that. But you know, I will just say you're not being judged on if Jamie sustains your ruling, she's not giving you points because she sustained the ruling or sustained the objection rather. If she overrules it, you're not losing points because it was overruled, right? That's not what Jamie's gonna be looking at, and I'll let Jamie explain that in a second. But um, as far as etiquette goes, witnesses remember that when an objection is made, you don't speak. That's not your turn to talk, okay? So I will say, as a presiding judge, if I have to admonish a witness to stop talking during objections, they will probably lose a point. And I have had to do that in the past. Did have to say a couple years ago, I had to tell a witness, I actually don't need your help making a decision here. So please stop talking. Um, and so, Jamie, do you have anything about witness etiquette, trial etiquette generally? We're going to stand to make objections, again, subject to any accommodation requests.
Yeah, and I think Stacy has joined us also, so we can loop her into these discussions. Um, yeah, I mean, referring to the judge as Your Honor is just always a good thing to do across the board. That way you don't have to remember the judge's name. Just every presiding judge you'll refer to as Your Honor. And being polite to opposing counsel. I've seen quite a range of this over the years that these trials can get very heated, especially with objections. And you could be going through one of these trials and the other side is objecting to every single question, it feels like, and you're getting mad about it. And I know that because as an attorney, I feel the same way. But just keep your cool. And if you do feel the need to address the objecting attorney, refrain from doing that and just address the presiding judge. And when there's an objection pending, you're not going back and forth with the other attorney. You're going back and forth with the presiding judge as an intermediary. So that's important to remember too. And sometimes a team's strategy is going to be to try to rile up the questioning attorney, and that's why they're making all these objections. Don't take it personally. It doesn't mean anything about how good your questions are. That just might be a strategy of the other side. So that's just one thing I'll add there. I'll have more to say on objections. I think we're going to get more specific on that a little bit later, but that's the main things that I wanted to add.
Yeah, so yeah, this was kind of just a brief etiquette kind of portion of it about the general approach, not getting into the specifics of objections just yet. We'll do that a little bit later on. But yeah, try not to turn and address each other because that always starts to go south very, very quickly. And don't assume that the judge wants to hear more from you either. You can say, Your Honor, may I respond? Because I may say, no, I'm going to make my ruling. And I'll give you an example from real life when I was really in court one day, and me and several other attorneys are just sitting there in a row waiting because there's a couple of attorneys talking to the judge, and those attorneys turned and started arguing directly with each other. And I will say the four of us sitting there kind of waiting all just like started leaning back. Like we were trying to get a little bit further away from like what was happening because the judge got pretty mad pretty quickly. And so I'm gonna say in mock trial, we're gonna be a lot nicer to you than that, but it still gets real annoying if you turn and start arguing with each other instead of addressing your objections to the court. Because I'm the one who makes a decision, not the other person. So just remember etiquette wise, we're gonna present those arguments to the court, not at each other. Um, okay, and so I think that's kind of where I'm at. There is a mock trial judges panel on YouTube. I think Jamie stars in that one. Feel free to go watch that one. Some of our longtime judges got together and just gave some feedback on what they like, what they don't like, things that they've seen that haven't really worked for teams. And so that's just their personal opinion. But if you're new, especially if you're new and you're trying to gobble up all the information you can, that's going to be a really great approach. And then just like in general, um, our YouTube page is going to have all of our previous virtual clinics are all on there. So you can go watch us say practically the same thing multiple times. You're going to see Jamie's warning about shoes every single year. Um, right, you're going to see some of the same things, but we might change up what we say a little bit from year to year. So it doesn't hurt to watch those things. And so those are all on there. And then also we have previous state competition rounds, our state final rounds. So you can watch what some of the best teams look like at that final round and what they're doing. I will kind of give the caveat that they're generally pretty tired by the time they get to that round. That's not necessarily their very best mock trial when they get to the round. It's still very, very good, however. Um, but that comes, if you make it to the championship round, I believe that's your sixth round in 2 days. So you've done a lot of mock trial up to that point, and so it can be a little exhausting. Um, Sydney's asking a great question. If you have an objection, just yell it out. No. We'll talk about that in a second when we get to objections more specifically, but I'll go ahead and say it now. You stand very calmly and you say objection, and then you state the grounds for your objection. And we'll remind you of that in just a minute. So,
And
um,
sorry, I had one other question in the chat that I'm actually not sure of the answer to.
uh,
And it was a question about communication. If a witness does not understand the question, is it okay to translate the question into another language so that they can understand?
no.
Okay. I just wasn't sure if we had anything for that.
I mean, in theory, you guys should have been prepared. Like on direct, the witness should never be confused by a question on direct because you should have practiced all the questions you're going to be asking on direct. But no, there's not really an opportunity to translate. The witness can say, I'm sorry, I didn't understand your question. Can you rephrase it? That is perfectly acceptable. I occasionally have my witnesses do that in real life because I end up saying something kind of convoluted. And so, as an attorney, you just go, okay, yes. And then you can either restate the question or you can try to rephrase it on the spot. But that's totally fine if a witness doesn't understand, they can ask for clarification. So let me switch my PowerPoints very quickly to the next one that Stacy's gonna get to help present. Yay, Stacy. Stacy, do you want to introduce yourself since you popped in a little bit after we did introductions?
Yeah, I'm happy to. Hi, everyone. Can you hear me? Okay, good. Great. My name is Stacy McNulty. I have been practicing for a long time, and I'm very grateful to be putting on this clinic with these wonderful teachers. Um, I started doing patent litigation and trial work. I then went in-house at a tech company and was in charge of their global litigation practice. And now I continue to do trial work, mostly federal cases, but I have also, done criminal defense work, other type of pro bono work representing people. So I'm happy to be here. The other piece of information that might be important about me is I don't have any lawyers in my family. So to me, I would have wanted something like this in high school. I didn't have this opportunity. And so I think anyone who's interested in the law or trial, I just encourage you to go all in because it's great.
Yeah, and so we're going to get into kind of dissecting a case. Where do we start? What do we do? And Stacy, just for your benefit, I think I told you this, but this is the presentation you gave 2 years ago, so you should know all of
I know this, yeah.
it. So we're going to start with, I guess, kind of the case we're going to use today, Little Mermaid. Stacy, you want to walk us through the basics of the Little Mermaid?
Right, yes. I know this like the back of my hand. So there's Ariel. She is the main character. She really wants to have legs and be a human because she falls in love with this prince who she only saw and kissed. Um, so she decides to go to the sea witch Ursula, you see on the left, and they make a deal of sorts, where she agrees to give her voice, which is that little ball you see, in exchange for 3 days as a human. If you saw the movie when you were little, um, or even now, you would remember that, there's some changes along the way. She can't speak while she's on land. And so the question in our case is whether a contract was formed. So that is what we're going to be focusing on today is this interaction. Uh, I believe she says, flotsam, jetsam, now I've got you. So go ahead and sign the scroll, something like that. She does. Um, and then later, she doesn't kiss him by the 3 days. She's turned into a poor, unfortunate soul, and becomes the property of Ursula. So I think that touches the basics.
Yeah. I would say, yeah, so we're kind of we're using it as a basis for today because most people have heard of The Little Mermaid or watched it or know about it. So that way, we didn't want you guys to have to go read a case for today. So we have the Little Mermaid contract dispute. Basically, they reached this contract. So Ursula's going to sue Ariel for breach of contract. She's going to say that Ariel breached the contract when she didn't kiss Eric by sunset on the third day, and because of her breach, she must be turned into a sad seaweed pet. Ariel's going to say there was no valid contract, so it shouldn't have to happen. So that's what we're going to focus on today. We're not going to focus on necessarily Ursula's poor behavior. I would say in the effectiveness of the contract, but we're going to focus on was there a contract because we're just going to really try to narrow it down for you guys so that you understand what to look at, where to start. Stacy?
Okay. So this is basically when you want to go, when you get your case materials and you want to start putting together everything. I call it dissecting the case, but basically it's like we're going to give you a roadmap of like let's get a plan to read everything, what's important, and then to start putting together your outlines, your scripts for your direct cross opening, all those things. So that's kind of what we're trying to do here, because it can be overwhelming. So very first, read the elements of the crime or the elements of the cause of action. So in this case, it is a cause of action for breach of contract. And in your packet, there will be a bunch of text with little bullet points listing elements, and you need to know those because this is what the plaintiff needs to prove, and this is what the defendant needs to challenge or contradict. So we'll start there. Then you review the witness statements for both parties and the exhibits that will come in your packet. So what you're going to be thinking about here is you're going to start with the elements of the crime or the cause of action. So the contract elements in this case. And we're going to see how the witness statements, how the things they say kind of support or refute an element of a contract. So then you've read everything that's there, right? That's a lot of reading. But then you go back to your case. So if you're the plaintiff, you're going to look for the plaintiff's witnesses, the ones that you will be putting on. Review, look at all of those, and then go back to the elements of the cause of action, and you're going to start making an outline that matches this evidence that you've read to build your case. So you will know what witness, what statement they have is going to be most important to proving the elements of the cause of action. Okay, so here, Texoma law, a valid and enforceable contract is offer, acceptance, mutual consideration, so something of value you exchange, and the parties being capable of forming a contract for a legal purpose and in writing. So if Ariel was like a minor, that would be an issue, but I don't think we're going to go into that today. So the cause of action for breach that Ursula has to prove is there was a contract, so she has to prove all of that. Then she has to prove performance or partial performance by the plaintiff. So Ursula did her part. She turned Ariel into a human. And then material breach or non-performance by the defendant Ariel. So, and then damages. So Ursula suffered damages. We'll think about what that could be. But so in Ariel not performing her part, that material breach would be not kissing Prince Eric by sundown on the third day.
Yeah, and just for clarity, this would be like the entire elements for a breach of contract cause of action. And then I think on the next slide, I have it kind of like we're
Like,
only
what are we
gonna
focusing on?
we're gonna focus on is there a contract, yes or no? And so that's gonna be that first bullet point.
Yes.
Because otherwise we'd be here kind of all day just chitty chatting about the Little Mermaid. And that would be great, but
Right.
also not productive. There you go.
So we're going to focus on whether or not there's a contract. So that was like that first part that I went through. So we've got offer, acceptance, and consideration. Was the off, and so goes into like more of the law about it. This will help you use, these are the words that you would want to use when you are advocating. So the offer has to be communicated. So Ursula had to actually communicate these terms to Ariel, and they had to be sufficiently definite or specific so that if they're accepted, there would be a contract. There has to be acceptance by Ariel or Ursula, clear acceptance of those exact terms that were offered. And then there has to be this mutual consideration. So there's got to be something of value that both parties exchanged. That doesn't have to be money. So it could be like an agreement to do something or not to do something. So sometimes like, for example, a covenant not to sue, you've heard of those, maybe, or an NDA, non-disclosure, you're agreeing not to do something you're generally allowed to do, which is disclose information. So that's kind of an example of that. Okay, so that's what we're going to focus on, offer acceptance consideration. So in simple terms, did Ursula communicate the offer to Ariel? Were those terms clear and definite? Did she explain what would happen, what Ariel had to do? Did Ariel accept those terms? And did they exchange mutual consideration? So Ariel got legs in exchange for blank. Ariel got to stay a mermaid in exchange for doing blank. Ursula turned Ariel into a human in exchange for Ariel's voice, I guess. Yes. So those are the things that the plaintiff will want to prove that the terms were clear and definite, and Ariel will want to, challenge as the defendant.
And so, yeah, so in this case, Ariel might want to say, well, there wasn't mutual consideration. Ursula got all the benefits of this deal. I got actually nothing out of it. But in this case, Ariel got legs. So she did get something. She got what she wanted. Did Ariel accept the terms as offered? She might say, well, Ursula included terms that we didn't discuss. I didn't know that what the outcome was going to be. I didn't know that it was going to be 3 days. I was given the impression I would have more time or whatever. Um, so those are things that Ariel can kind of discuss. And so next, you're going to plan to prove each element with supporting evidence. And that evidence includes testimony of witnesses from either side, because you might get testimony out of Ariel that proves there was a contract. For instance, if you're representing Ursula, you're going to definitely try to get Ariel to admit to some of those things, but it also is going to include your exhibits. And like I said, we're going to get into the nitty-gritty of like how we question witnesses and all of that in a second. But this is just kind of like, where do we start? How do we figure out what the purpose of each of these things
Yeah.
are?
So I think the most important is that you've got these exhibits in your packet that can be evidence, but evidence is also what someone testifies about. So don't discount, what someone for the other side saying that can go to prove an element if you need to use it. Okay, so here's an example for the plaintiff. So you're going to go through and review your plaintiff witness statements. So in this hypothetical, right, the plaintiff is Ursula. So we're going to go through and review the witness statements that we have in our packet for Ursula's. Usually there'll be 3, so that will support Ursula's case. So it's probably going to be Ursula. It may be like Flotsam and Jetsam, one of her buddies, something like that, and a police officer or something like that. So that is usually, you want to read those. And then here's what I do, and I think it is, especially when you're starting, I still do it now for trial. I use the how question. So for each element, I've convinced myself that we are going to win this or we have good arguments. And then I say, how do we know there was an offer? How do I know that? I read all this stuff. What told me there was an offer? How do I know? And the answer is that's the evidence that you need. So I know there was an offer because, Ursula's witness statement said that she communicated things, but Ariel also admits in her witness statement that Ursula communicated to her these specific terms. So there might be more than one way, but when you ask yourself, like, how do I know there was an offer? Well, she said this, and the offer was written down on a scroll, things like that. So that's the answer is going to help you identify the evidence that you need to prove each of those elements. Okay, so here's an answer. How do I know that Ursula communicated an offer to Ariel that was clear and definite? So we've got testimony here. Ursula will testify. She told Ariel her terms out loud. She says, she would take the stand and she'd say, I told her I would turn her into a human in exchange for her voice. So we've got those terms. And I also told her she could stay a mermaid if she kissed him by the 3rd day. And if she didn't, she'd belong to me. So
I think it's supposed to be stay a human. I think I messed that up. I think she's supposed to stay a human if she kisses Eric by the 3rd day, but I don't
oh yeah,
remember the
yeah.
details of the
She would
case.
remain right.
She'd remain a human. So that's on me. That's on me. That's not on Stacy, to be very clear. I was just been reading this going like, I don't think that makes sense. But yeah, so if she doesn't kiss Eric, then she turns into the little sad seaweed pet that we saw at the beginning.
But here's an example of how we can use statements of multiple witnesses. So both Ursula and Ariel can testify that they talked about these details of the offer. So like there's this whole song that they sing, but as a part of it, Ariel goes, but without my voice, she's wondering how can she convince Eric to kiss her? And Ursula goes on and says, like, you'll have your looks, your pretty face. I'm not going to sing, but that's how it goes. And so that's evidence that Ariel would have to admit to as well in her testimony on cross, that they did discuss that she wouldn't have her voice during that time, those 3 days. So here's some evidence of the offer that like you may see in the movie. And I put the subtitle, we got the subtitles here. Before the sun sets on the 3rd day, you must get dear old Princey to fall in love with you. and kiss you, not just any kiss, the kiss of true love. So here's an example of Ursula saying, no, I told her very clearly what the terms were. It had to be this crazy kiss. So how do we know the parties exchanged mutual consideration? Let's go here. So this is if you guys are familiar with the story, but this is like a discussion point. So can you guys think of some different pieces of evidence that would, who might testify about actually exchanging consideration? You can put it in the chat or you can raise your hand. Jessica, do you have any thoughts?
There's a reason it says you tell us because I got very tired writing this particular slide. But I would say, oh, the sea pets, she had the other characters. That's evidence of mutual consideration. So Ursula, I guess, already has some of them, so we know exactly what Ariel's going to turn into, and what Ursula gets out of it is more sea pets if it's not done correctly. So you're right on that one. Renee, thank you for that one. If anybody else has ideas about so when we talk about mutual consideration, we're talking about what each person gets out of the contract. And that may be a promise from the other person not to do something. So she lost her voice. So Ursula gained Ariel's voice, but Ariel got legs. So they each got something in that exchange. That's a great response, Christina.
Right.
Like that's going to be the mutual consideration. That's the primary mutual consideration, right? And then there's really kind of two things, right? There's an exchange where Ursula gets the voice and Errol gets the legs, but then Errol has to kiss Eric to keep the legs, and if she doesn't, then Ursula will get another C pet. And so that's a second kind of round of consideration. Oh, Michaela, a
Oh, this
possible
is a great,
witness.
yeah.
Yeah.
So this is a great way to say like, oh, there's other sources of evidence besides just the two of them. So you're saying like Sebastian could testify because he was there, he saw that Ariel got legs and he freaked out about it, right? And then he
Yeah.
went and told her dad.
Yeah,
So yeah,
Sebastian.
that's a
Yeah.
great, like if Sebastian had a witness statement, I'm sure he would say in there that he found out about it and he would admit it. So that's a great source of evidence
Yeah.
about the consideration.
And he was freaking out because he thought it was a real bad deal for Ariel, but he's also going to say, yeah, she got turned into a human. She grew legs. Like
Yeah.
I saw it with my own little crabby eyes. So that was great, Michaela. Anybody else have any suggestions about how we know there was mutual consideration? So in this case, like we're saying, like we know there was mutual consideration because we actually see it, right? It actually happened. That initial exchange actually happened. So that would be what we want the witnesses to testify to. And so from Ursula's point of view, where Ursula wants to prove there was a contract, she's got to prove there was consideration. So she's going to ask Ariel, or her attorney rather, and you actually got turned into a human, didn't you? Like you didn't get nothing out of this. You got turned into the human just like you wanted to, right? Um, and so yeah, we've got a scroll as evidence, like Price mentioned. We've got other forms of
Mhm.
evidence to put in to show that we have everything written down, what each party is going to get out of the agreement. And so,
So yeah, like another example is that so Ursula got Ariel's voice, and I think in the movie later she actually uses it. So that's like ongoing proof that she received that.
mhm. Okay, and then so we've
Okay.
already kind of addressed this a little bit, I think,
Mhm.
but we can go over it again as evidence of acceptance. We know it was accepted. We've got the scroll as we mentioned in the chat. Um, we've got that as an actual exhibit that can be presented, but we also have evidence of acceptance in that, you know, Ariel went to land and used her little human legs and tried to do her part of it, I guess, would be something.
Yeah. So we've got the exhibit, and then we also have witness testimony that we could talk. So you could introduce the scroll, when you're questioning Ariel, for example, and say, like, is this your signature? Did you sign this? And it lists all these terms, doesn't it? So um, that's a way that you could use both the exhibit and the testimony.
Yeah, and you also would have Sebastian. You'd be like, Sebastian, you were there, you saw her
Yeah.
sign it. Nobody signed it for her. She actually agreed to the terms of the contract. Um, so while they had a verbal agreement, they actually did uh, reduce the agreement to writing. I had to think really hard on the words I was going to use. So we do have a scroll as well, but we have witnesses who can testify to the actual conversation that they had, that it was accepted, and then that they also signed the agreement. And so now we're going to go to the defense side, Ariel's side. Her side's going to be a little harder because the facts of the actual movie make it impossible, but we're going to imagine some facts maybe she can introduce.
Yes, disclaimer. Okay, so just like we did before, the process we're going to go through is Ariel's going to read all of her witness statements, and she's going to look at all the exhibits for anything that's going to disprove or challenge any of the elements. And so we're going to do this same thing, like what tells us it was not accepted? How do I know that this wasn't accepted? Did she try and change the terms and therefore didn't accept it? So what tells us Ariel didn't get anything of value in exchange for this?
Oh, sorry.
It's cool.
So we don't
So
have a
that's
lot of
just, yeah,
slides for Ariel's just because the actual facts in the
yeah,
movie
because
don't
it's
give us
tough.
a lot. But if we were looking at like the whole cause of action, right, which would be performance, breach, damages, Ariel would have an argument that she couldn't uphold her contract, the terms of the contract, because Ursula interfered, right? That would be an example of some of the other parts of that cause of action because, when she tried to kiss Eric, for example, I think Flotsam and Jetsam like upended their boat or whatever
Yes.
when they were about to have their first true kiss of love, first kiss of true love or whatever. So, she'd be able to bring that up from parts of the other elements. So she maybe doesn't have a strong case on is there a contract, but she maybe has a better case on some of those other elements. And so,
So now we've talked about like when you are dissecting your case, we've identified the different pieces of evidence or testimony that are going to prove the elements. And now we're going to think about how we actually present our case. So you have your opening statements, then you question your witnesses, and you have closing statements. So a very effective thing to do is create a theme for your case. So if we're on Ursula's side, the theme for your case could be you might not like it, but you agreed to it. Something like that, right? Like you don't like what happened, but you knew exactly what the terms were. Something like that. So these are examples that this is what everyone does when we're going to trial. It's kind of the takeaway that you want a jury to remember. So the O.J. Simpson trial, which I'm sure was like well before your time, but you probably have heard the saying, if the glove doesn't fit, you must acquit. And that's something that the jury took back with them, took very seriously. The glove didn't fit, so they acquitted O.J. of that crime. Um, this example is from a different case. So, but like an example here, um, I think here is Ariel knew exactly what she was getting into. Something like that. She still has to abide by the terms she agreed to.
like
So,
a quick thing might be Ariel didn't keep her word or Ariel didn't keep her
mhm.
promise, right? Something along that line where we just want to have like a quick hit thing and then yeah, so I'm sorry, I didn't catch this in the
That's fine.
slide,
I was
but
like,
we had a case a couple years ago where there was a party magician, I think it set a fire or something. I'm not sure it hurt somebody,
yeah.
and they were trying to make it out like he was a hardened criminal. So the theme of that case was birthday party magicians aren't life-threatening. They're not,
Mhm.
they're mostly just doing magic, like very basic tricks of like pulling a card behind your ear or some coin bound to your ear or something like that. So,
Mhm.
um, but we want it to be kind of a quick hit and it's going to be something that you can like revisit later on.
Yep. So you're gonna try and like make that theme reoccur. So definitely it has to happen during opening statements because that's kind of your message that you're trying to get across. That's really your only opportunity to advocate. And then during cross and direct, you want to bring that back up if you can. So especially this is an important one that gets you points and is very effective with the jury or the panel in your case. So if you can make the other side's witness say part of it or agree with your theme in context, that is a great way to make sure the jury remembers it, as if you get someone else to say it. Then you'd repeat it again during closing. So that's it seems like, oh, we're telling you this abstract thing, but as you've gotten to know now the elements, the theme, what everyone's saying, all the witnesses are saying, you'll be able to come up with a case theme. It doesn't have to rhyme. Okay, so next you've thought about your theme, so then that's where we actually are going to create your proof outline and then your examination scripts. So this is kind of what we talked about at the beginning that you were doing like mentally, but you should write this down because this is going to be what's helpful when you're actually in trial. You might need to refer to this. So we would list out the elements of the cause of action that you need to prove or disprove, especially if there's ones that you're challenging very, directly as a defendant. And so you make a bullet point or a list, and then under each one, you're going to list out your proof, and that's yours. So what helps you? So the witness that can establish the element through direct exam. So if you are the plaintiff, Ursula, it's going to be your witnesses that will be able to say something, as well as exhibits that can establish the element. You can also identify witnesses that can establish these points through cross-examination. But if you think about it, if I'm on the plaintiff side, Ursula's side, and there's a very different type of question, which we'll get into later, Ursula, of course, can say, yes, I told her that she had 3 days. That's part of this is a friendly witness, we say, but then when we cross-examine Ariel, which could happen much later in the case, we could also have her admit that Ursula told her she only had 3 days and she wouldn't have a voice, etc. So now this is your proof outline for your side. Throughout the course of mock trial, you're going to have to present both sides, but in my mind, it's helpful to have a proof outline for the plaintiff and the proof outline for the defendant. You should be familiar with the other side's proof, like what are they going to use? Are they going to try and discredit your witnesses? So you need to know what they're going to say, but for your proof outline, you just need to keep straight what it is that's proving your elements or challenging the other sides. So then after you've kind of put your proof outline together, create your case plan. So that's going to be scripts for your witnesses. So first it's the direct examination script. So you will have for both the plaintiff and the defendant, there will be witness statements, and usually you're assigned 3 witnesses. And so you're going to make a script for those witnesses, and that is using a certain types of questions that allows the witness to be the star and tell the story. And you're going to make sure you get all of those elements that the witness is able to testify to. You cannot go outside the scope of what their witness statement says. So in the direct examination, in that script, you'll also flag exhibits that you would want to use and the foundation questions. So I'm talking about like the physical exhibits that will be in your packet. So within the script, you'd say, okay, now I want to introduce, for example, the scroll. There are rules for how you have to establish foundation for the scroll, and you will write that in your script so that you'll know that you did it. You don't have to read it, but while you're actually doing it, but having it there to make sure you're ticking off those elements, establishing foundation so that you can get your evidence in is really important. And then the last thing you're going to do in these direct exam scripts is you're going to try and, if there's some not so good facts for you. You want to kind of explain or consider explaining, or kind of, we call it taking the sting out of like a bad fact. So if there's something that's really going to harm you, sometimes it's better if your witness can explain it first. So you like your story gets told first, as rather than having like an aha moment later on the other side. So you wrote your direct exam scripts. Then you're going to write your opening statement that refers to what you know the jury is going to hear. Um, so you'll say, we're going to prove these elements, and you're going to hear from Ursula. She will tell you that there was a clear offer of these things. So that's what your opening statement kind of like outlines what you will do. And then next you will make cross scripts. So that is how you're going to cross-examine the witnesses for the other side. And we'll get into this in more detail, but those are a different type of questions. Those are closed questions that are only asking for yes or no. So, for example, Ariel, after she gave you the scroll, you signed that scroll, didn't you? She either says yes or no. The answer is yes. So that is an example of a question we'd put in the cross-exam script for the other side's witness. After you've done your cross-exam scripts, you will write your closing statement. That's going to kind of be like the bookend. You've got your opening statement that says your theme, tells what you are going to present. Your closing statement is going to kind of mirror that theme. And it's also going to say, like, you heard. How do you know that an offer was communicated? Well, today you heard from these witnesses. You saw a scroll. So that's kind of how I think that's the best order to kind of put together your case. And those are so like this outline I think is an important one because it kind of tells you what documents like you need to put together in order to do it. The closing statement, I will say, needs to be something that's a little bit fluid because you never know exactly what is going to come out during the other side. So you need to be able to adjust your closing statement. Certainly, you don't want to say, you heard from so-and-so during your closing statement when in fact the jury did not hear from so-and-so. So someone asked earlier about whether you should memorize your closing statements. Yeah, I think that you should memorize your themes, but you need to make sure that they are adapting to address what actually happened during the trial. Just to make sure that it's still accurate and still, using what happened to advocate your side.
Yeah, beautiful, Stacy. Love it. As a kind of an additional, I don't have an extra slide. I don't think we have an extra slide on opening and closing statements, but um, I think an instinct we sometimes see in opening is to address all of the evidence that the other side's gonna present, so you can kind of
That's a
negate
great
it.
point, yeah.
Um, it's it's fine to do that, but you don't want to do it at the sake of actually talking about your case. I did have an opening statement that I heard a couple years ago where they kind of talked about their case just a teeny tiny bit, and then they talked a lot about the other side's case. And me as a presiding judge, like I knew kind of what the case was about. I knew that it was a balanced case. There was stuff on either side. But just listening to the opening statement, I kind of went, oh, so you plaintiff don't actually have a case, is what it sounds like, because you haven't talked about your case. So it's fine to talk about the other side. Remember, you only have 5 minutes in opening. Talk about your case. Talk about what you're
Mhm.
going to prove or disprove if you're the defendant. Talk about why the jury should believe what you're presenting to them, and then highlight the parts on the other side, right? Don't necessarily spend a lot of time in opening trying to disprove every single thing they're going to say. Um,
Mhm.
you know, I didn't give this disclaimer up front, but I did not write the case. Jamie did not write the case. Stacy did not write the case this year. If there's any similarities to the actual case that's being presented, they are complete accidents because I know it's an employment discrimination case. I don't even know what kind of discrimination it is. That's how uninvolved I was this year. So, if we say something where you're like, oh, she's definitely talking about our actual problem,
Or not.
it's a beautiful accident, is what we're going to
Yeah.
say. Um, so but you don't like, so for example, and I say that because I'm just going to give you an example. I don't even know if it's present this year. If you have a witness for the defense that, for example, is making a lot of money for their testimony, we had this a couple years ago. We had an expert on the defense side who made a couple $1 million, I want to say, for his testimony. Um, you don't want to spend a lot of time spelling out all of his testimony and spelling out exactly how much you wanted to make, but you could definitely say something like, hey, and you're going to hear from their expert witness, and I really want you to think about how much money he's getting paid today to testify. So when he's talking, keep in mind how much money he's making. Right? You really just want to kind of highlight that. You don't want to give a lot of credence to what he's actually going to say. You want to just attack that credibility up front. So that's what the jury's thinking about, would be an example that I would give you. Jamie, do you
Another
have any?
effective thing, I think, to go off of Jessica's point, another effective way to like do this without telling the other side's case, but poking holes in it, is saying like what you're not going to hear from the plaintiff, or what I suspect we will not hear about at all is blank. So like that's an effective way of kind of poking holes in the case without really going into, and you will know those things because when you look at the witness statements, there nothing will be there. So like you're allowed to make those types of points because the witness can't go further than their statement.
Yeah, Jamie, Kevin, y'all have any insight, tips, tricks for this portion that we've gone through?
Not much. I think you guys really covered everything thoroughly. There is one question in the chat I think we can address, which asks, can an expert witness testify to the facts of the case as long as they have sufficient data to draw conclusions from their expert opinion and research? So it's a really good question. And what you need to think about here is, let's say in this case, there's an expert who is a voice doctor, maybe a laryngologist or something like that is probably what that's called. And is the jury going to care about what the voice doctor has to say about what Ariel and Ursula talked about the day they made the contract? No, because that doctor wasn't there. What they're going to care about is when that doctor is informed of the facts, and they can certainly say, I'm aware of facts X, Y, and Z, and I form my opinion based on those facts. This is my opinion. And so it's sort of a complicated answer because of course, they're going to talk about the facts because that's what helps them formulate their opinions, but they're not an eyewitness. And so they're not going to take the stand and say, well, I saw Ursula say this, because they just didn't. So it wouldn't be as effective as having an eyewitness give that information.
Yeah, that's a great point. They're not going to be able to say like, oh, there was a contract or whatever. But they could say, oh yeah, I examined Ariel and she definitely lost her voice, and I can confirm that the voice that Ursula had in her locket was Ariel's, right? So that's what that expert could testify to, but they wouldn't be able to say, and Ursula, they couldn't necessarily say Ursula took the voice and Ariel agreed that she could take the voice. That's not necessary, they can't necessarily testify to those facts, but they could testify to underlying things that would support the ultimate case, such as like, yeah, I can confirm Ariel did lose her voice. I can confirm that was Ariel's voice in the locket, etc. Um,
To chime in, with your opening statements. Your opening statements are really your opportunity to tell a story. To obviously you're trying to explain kind of your case and what you're trying to do, but it's also an opportunity for you to plant the seeds of just of engaging with the jury, because part of the advocacy part of the competition is making is that engagement with the jury, and people like stories and being told stories, like the Little Mermaid is a story, and presenting your side in a fun and engaging way is one way of doing that, and you can really do that in your opening. During testimony, it's a little bit harder to do that because of the nature of questioning witnesses and things like that. But your openings and closings are really where your creativity as a team can really shine as to presenting your case.
That's a great point, Kevin. And another example in this case would be Ariel. Ariel's not going to want to focus necessarily on was there a contract, right? Because that's not a great argument for her to really attack. She's going to want to attack Ursula's credibility, right? She's going to want to attack the fact that she's a literal sea witch, that she literally enslaves people, that she literally only does things for her advantage, right? That's what the theme of Ariel's
Mhm.
opening would want to be. You're not going to want to present Ursula's case
Right.
because that doesn't help Ariel at all. So that's kind of what we were talking about a little bit is make sure in your opening you're addressing your case primarily. And like Stacey said, things that are missing from the other case, like Jamie said, like things that don't necessarily help the other side. You want to kind of focus on those things. But you really want to set the scene for the jury to say this is what this case is about and this is what you're going to hear today and this is what and there's all sorts of ways to do that. Go get on the internet, watch some beautiful, amazing opening statements. Some movies have great opening statements. Some
Mhm.
movies have opening statements that would probably get you held in contempt. Um, but they're still fun. And so maybe you can find a non-contemptuous way to say, members of the jury, everything that man said is BS. Maybe don't actually say that, but you can find a
Yeah.
version of it that maybe won't get you thrown out of a courtroom. And so that is an area where outside research can be wonderful and very helpful, is to just,
Mhm.
figure out what works for you. And figure out what works for you. I see a lot of times students have written their opening statements and they're trying to say word for word what they wrote. Remember that the way we talk is not the same way we write. That's true for almost everybody. I do not write the same way that I speak. So you can start by writing an opening statement, but then figure out how you can deliver it. No, you will not actually be held in contempt in a mock trial setting. You might, however, lose points depending on what you do. Depending on what you do. No one's going to throw you in jail in mock trial. But yeah, so just because you've written it one way, don't try to read it word for word out loud. It may not deliver the same way. You may find that the way you say things or deliver things out loud is different. And so I encourage you to say, once you've written that opening statement, say it out loud a bunch of times. Figure out what words actually work for you. And then as you say it and you figure out what works, then you go back and you revise your statement to like what you're actually saying. So that'll help you memorize it a little bit better. Um, but yeah, so we're gonna move on to witness examination. Stacey, are you staying with us? Do you gotta go?
I can stay for a little bit. Yes.
Okay, cool. So I'm gonna again, these are a lot of things that Stacey's helped write and develop with me over the past couple years. So we're gonna kind of do the heavy lifting and throw it to Jamie and Kevin a little bit here or there. And then once we finish kind of this portion, then Jamie's gonna be in charge of some Jeopardy for you guys. And so we're also going to try to give some opportunities for maybe our intermediate advanced students to just throw their suggestions into the chat. Like, what would you ask these witnesses? How would you phrase this question? So we're going to try to allow for some participation as we go through as well, so that those of you who have done this before, you have an opportunity to really try and do some of it on your own, if that makes sense. So, Stacy,
Hello.
hello. Do you want to take over?
Um, can you run the slides?
Yeah, yeah, I'm running the slides.
Okay. Yes.
That's fine. So yeah, we're gonna start with witness examination. So we're gonna start with,
Perfect.
a trial is a story. And each witness exam is gonna be a new chapter to that story. They're gonna flow, they're gonna connect. If a witness is on direct, you want them to tell their story. You want them to build credibility with the jury. You want them to be able to present who they are, all the information that they have. If a witness is on cross, you want to hurt the story they're trying to tell and find ways to get that witness to agree to your story. Kind of the other thing we say is like on on direct, the witness is the star. On cross, the attorney is the star. Right? Is
Yeah.
kind of how we look at that. And then I have some stuff about criminal stuff that doesn't apply to our cases here because it is civil. Stacey?
Yes. Okay, so let's start with direct exam. Is that good?
Yeah, what's next?
Okay. So, so for direct exam, I just am not seeing anything. Sorry.
Oh, did I not? Oh, hold on,
Yeah, I
hold
was
on. I
like,
forgot. I'm so sorry. I
Yeah, not sharing.
I'm like, why does Stacy not know what to
she's not
say?
doing
It's in
anything.
her face. When I switch
Okay.
between PowerPoints, I forget that I have to
Yeah.
reshare each time. So, um, hold on. I got
Okay.
this beautiful, beautiful witness exam. Trial is a
Perfect.
story, what I just said. And we have our stages of examination, which we talked about in the rules a little bit. We're going to do direct, cross, redirect, recross, and then the witness goes away. I mean, not forever. They go sit back in their chair. So we're just not going to go endlessly. And so direct examination.
Okay, so we talked about how when you are the primary goal of direct examination is yes, you're telling your story, but you're telling the story in a way that's going to develop those facts that you need to prove your case. So that has to come in the form of a story, otherwise a jury would just be like, "What are you talking about?" Right? It has to come in context. Um, but what pieces can this fill in? What you need to ask is how are we going to get this vaccine? Will this establish credentials for the witness? And then we also need to think about establishing a foundation for the exhibit. So the most important thing I think for direct examination when you are putting together your outline with your witness is that they should be talking. And I know that like when it's your opportunity, especially for the plaintiff, so you're the first one to put on a witness, you're gonna like you're like I'm ready to go, like let's ask all these questions, but really you want to ask questions that really just let the witness run with it. You are really there to just guide the testimony in a way to make sure we're hitting the points. So the witness is a star. Questions should be open-ended. So what happened next? There we go. Who, what, when, where, why, and how. How is like a very, for me, um, important one because that allows a witness to just run. Um, but when we ask, like, what did you see next? When did you first meet Ariel? Where did you hear about someone who could give you legs? Why would you want legs? So those are examples of like questions that you're going to use to help guide. If I was putting on, for example, Ursula, I'm going to say, when did you first learn Ariel wanted legs? Something like that. And she'll say, well, Ariel came into my cave and, was very distressed. So that's kind of those, when you are writing down, write those words at the top and only prepare questions that use those words. You're going to want to introduce them to the jury, their name, kind of their context, like Ursula, who are you? How did you come about this? Well, I'm a sea witch. I have magic powers. So that's kind of, we've got to give the jury context. You also want to establish credibility. So, for example, for Ursula, we talked about how she like had a whole bunch of these like sea pet urchin things. And so we're gonna want to say like this is not the first time you've done a deal, right? That you've used your magic to give someone something they want. No, it's not. I do this all the time. I help people in need. So that's gonna it's not great credibility, but it establishes that she knows how to do a deal, right? Um, so then the other thing we want to think about in our questions is we're going to look through the statement. Is there anything like not so great there or something that discredits them? We want to try and this is kind of taking the sting out, or we want to see if that's something that we want the witness to explain first. And so I think with Ursula, it's a really great example of a witness that on direct, hey, you're just not likable. So we've got to kind of say, how many people have you, instead of saying, now you have a lot of these like urchin pets, right? Like you've got a lot of people that you now own. Um, And she says, yes, I've helped a lot of people that just didn't keep their ends of the bargain. So we've got to make that palatable and address it probably.
Yeah.
Um,
Yeah. So
yeah,
instead of you've turned bunches of people into little sea urchins, it's like you enter contracts with people all the time, right? And you've upheld your end of the agreement every single time, haven't you? Like, yeah, it's not my fault that they suck, right? Maybe she wouldn't want to say that, but you kind of want to like not talk about that she's got just like dozens and dozens and dozens of sea urchins because that implies maybe there's something not great going on with the contract she's writing, perhaps, but you want to, figure out a way to do that where it like makes her look like the good guy, not the bad guy. It's not her fault people don't keep up their ends of the bargains. And maybe you also say, but you've done lots and lots of contracts that both parties did what they were supposed to and it worked out just fine, right? And you've never seen that person again, right? Like that might also be something that hopefully it theoretically would be in Ursula's witness statement that she'd want to testify to that helps her not look like the bad person.
exactly. And then last, you can also sometimes it will help you to on direct exam to set up another witness in a positive or negative way. So like with Ursula, you can kind of go through like, wow, was Ariel just like, maybe she doesn't understand the practicalities, but she wanted to have legs and she wanted to be a human. And you know what? I told her the terms and gave her what she asked for. So like that's a way that by the way the questions that you ask and the testimony that you get from Ursula, you're kind of setting up the jury to think like maybe Ariel is a little unrealistic or, not she just didn't pay attention even though she knew exactly what was going on. So that's a way that you use one witness in direct to set up another witness.
I have this backwards. I'm so sorry.
This is
It's written
backwards.
Ursula
Yes.
for the plaintiff and Witten and Ariel for the defense. So
Yeah. So that's fine. Um, so directive Ursula, we talked a little bit about, but we're going to always start with like, hello, what is your name? Like always start there. And I think also from the advocacy side, it's really good because those are the easy questions that get you going. So you kind of get over the nerves. What's your job? Okay, well, I'm a sea witch. I have a whole bunch of magic powers and I um, use them for good and for bad, you know. So then why are you here today? So then we're going to put it in context and we're going to begin talking about the dispute between the parties. So I'm here today because I had a contract with this mermaid Ariel. She didn't hold up her end of the bargain, and so I filed a lawsuit. Then we start with the story. When did you first meet Ariel? Okay, so then we get to actually tell about these elements of building the contract. So exactly,
ah
just like
ah.
that. But that was beautiful. So you see how you like start with just like the basics so that just like when you meet someone at a party, you're kind of like, oh, what's your name? What do you do? Where do you go to school? And then you kind of, when you start talking about something specific, then you go into details. Um, so that this is kind of how you're going to always start a direct. But do you see how all these questions are when, why, what? And then if we need to emphasize something like, well, did you perform your side of the contract? She can say, yes, absolutely. I gave her legs. I sent her up to the surface with an air bubble. So she gets to tell about what she did specifically because that's probably very important to know as an element of the contract for Ursula's side.
Yeah, does anybody have ideas for other direct exam questions for Ursula that they think they would ask? You can unmute, you can tell me out loud, or you can type it in the chat. That's fine too.
Absolutely correct. Yes, I would not advise my witnesses say I use it for bad and good. You'd say I give people chances. I give them what they really want and need that they can't get themselves.
Yeah, that's a great tip for how a witness should answer the
Mhm.
questions.
Yeah.
Um, some other questions I think Ursula could ask is some I think important questions to ask of Ursula rather are, about the contract itself. Like, was a written contract presented? You know, what did Ariel do when she got the contract? Oh, she read it. She read it and then she signed it. Um,
And are these
yeah, can you
are these
provide?
business records? Do you keep these at the normal course of your business? So,
Yeah. Um,
so
a
you
great,
know, you would think about with Ursula introducing later that physical, if that was part of your packet, like that physical
yeah.
exhibit.
A great example of a question was, can you provide an example of when you helped somebody in the past? Not we're talking about Ariel's case, but other examples that where you've
Mhm.
entered into contracts with people and you've helped them, achieve what they really wanted. Um, we'll get into witnesses a little bit, but I guess, Jamie, can you answer this question? Should witnesses keep their responses broad?
It depends, which is the most lawyer-like answer that you can possibly give. I mean, it depends on the question. If you're on direct and the question is, can you please introduce yourself? Sure, you can be broad. You can say, my name's Ursula, I'm a sea witch. Here's what I do for a living. I live with these eels. I have these pets. That can be broad. If the question is something like, what day did you meet Ariel? Instead of saying, well, I think it could have been Friday because I went to the store on Friday morning and I bought some donuts and I came back and I ate 3 donuts and you just go on and on and on, then the jury's going to get impatient with that and they're going to think you have something to hide. So in that case, it's probably better if the witness just answers, oh, it was Friday. And it makes you seem confident and it doesn't make you look like you're trying to hide something.
Hmm. Um, and I guess when we talk about broadness, if it's like give an example of a time you helped somebody before, you don't want Ursula to just start saying, oh yeah, I help people all the time. I really help them. Whatever they ask me for, I help. You want her to get, you would say, no, I want an example. Like you need to give an example of, oh yeah, this fish came to me and he really wanted to be a different color. And so we entered into a contract. So instead of being blue, he could be red, which was his lifelong dream, was to be a red fish, for example. So that would be a place where you want to be specific, not broad. And so again, you'll be working on these together as teams. So these are places where if you as the witness, you're working with your attorney and the attorney asks you a question and you're like, wow, that's kind of vague. That's kind of broad. I don't really know what the answer is. In your preparation, in your teamwork, your collaboration, you would want to say, let's fix that question. Let's tailor it to make sure that we know exactly what we want to have come out in response to that. And that's
Mhm.
something that we do sometimes as attorneys when we do our prep work too. Like I'll go through the questions I want to ask my clients, and every once in a while they're like, I'm not really sure what you want me to say there. So then I'll be like, okay, let's restructure the question so
Mhm.
that when I ask the question, you know what I'm trying to solicit from you. So, another example in the chat was, are you aware if Ariel can read or not? That one might be hard because I don't know that Ursula's ever seen Ariel
Yeah, I would
read.
say that like in the legal context, like this is a great example of if the fact pattern doesn't say, we're not going to argue that she can't, because that would be like a material,
Mhm.
like that would really sway things. So we're just going to assume that everyone kind of normally can read. She is of school age, I would say. Um, so if the fact pattern doesn't explicitly say, we're just going to go with like, let's assume the
Yeah,
normal, especially if it's something like reading would impact, the enforceability of a contract.
exactly. And then on the flip side, Ariel's attorney is gonna want to do, a direct examination of her and what facts may be important for Ariel to get out. So again, what is your name? I'm Ariel, the youngest princess of King Triton.
And where do you live, Ariel?
Yeah, I live under the sea.
She's like, currently I'm a sea pet.
Yeah.
And so this is example of like, how did you first meet Ursula? Whereas if you asked Ursula the same thing, like Ursula's going to say this like little girl came in asking for me to make her fall in love. Whereas she's going to say, I heard about this witch that had magic powers and I fell in love and I knew if I had a chance that, we could be together. So, she can talk more about her motivation for doing this.
Yep.
Why did you go to the lair? And you can also like this would be a great example of like where she would say like, yeah, I mean, I didn't want to. Like, she's got all these powers. It's scary. Like, this is not someone I would normally deal with. Um,
Hmm, hmm.
what did you agree to? And so, yep,
Yeah.
let's see.
So does anybody have questions about direct examination before we go on to cross?
And remember that like sometimes shorter is better. That
Mhm.
goes for direct and that goes for cross too. So for like the
Yeah.
direct exam of Ariel, the facts aren't great here. So we're gonna get out that like maybe it was felt very unfair, the situation, and that she did her best to perform. But other than that, then we'll probably just sit down.
Yeah. So the question in the chat, how long do we wait or move on if they don't have an answer? Again, on direct, you should always have an answer because you
You'll be
guys
prepared.
have done this together beforehand.
Yep.
So we'll talk about that question in a second on cross-examination and what we should avoid on cross. We'll get into that in a second.
Mhm.
But for direct, again, we're telling a story. We want the witness to tell their story about what happened. And this is an opportunity for Ariel to establish that she wasn't just a dumb little girl who signed whatever without knowing what it was, that maybe she had a different understanding of what the contract would be. She had a different understanding of what the terms would be. Or maybe she didn't know. Maybe Ursula just didn't tell her part of it. And because I think somebody mentioned in the chat earlier, actually in the movie, the contract changes like after Ariel has signed it because Ursula uses her like sea witch powers. So that would be also something, you'd want to solicit from Ariel. Was this actually in the contract when you signed it? No, it wasn't. Okay, great. So we're gonna move on to cross-examination.
Yeah.
As an attorney, what should I advise a witness to do if for some reason they forget or don't know the answer to the question? Um, Jamie,
Is
you
there
have any
something that
questions?
would refresh your recollection? Maybe. So
Yeah.
I think basically like what let me like make you guys feel better is that direct examination, you and your witness are going to prepare your mind. Like you will know the back and forth so well. You don't have to memorize it, but you will be pretty close to memorizing it. The witness is going to stick so closely to the witness statement that they have that they know this like world of what they're going to testify about, okay? Because it's not going to go beyond the scope of that. So if they forget what is on the witness statement and they didn't bring it, you can ask if there's something that would refresh their recollection. And they'll say, "Well, I did bring it. I did write a witness statement." I mean, that might help. I'm so nervous on the stand, but generally, like direct exam, you will be prepared. So I wouldn't be concerned with that as much, just because the witnesses are really they've got 1 or 2 pages that they need to know, and they'll be able to know it.
Yeah, and again on direct, that's enough. What sometimes helps is you can say, okay, let me go back one question and then we'll
Mhm.
go back through that and kind of remember like where we are. Because sometimes when that happens, I find when as the presiding judge, when people get lost as to where they are is because we had a whole back and forth about an objection. And so
Mhm.
everybody's kind of lost the plot of like where we are in the direct examination.
Yeah.
So it can be helpful to like back up a question, refresh the memory
Mhm.
of like what we just talked about. Okay, and then
Yeah.
you said you went to Ursula's lair for da da da, and so
Mhm.
then what happened after that, right? So just
And
to that
while
can
you
help.
shouldn't do it all the time, it's totally appropriate to say, okay, we were talking about when you first went to Ursula's lair. I asked you what you two talked about or what she said, what you heard, or, so that it's okay to
Yeah.
kind of preface your question with context, especially in that situation where there's been a disruption. And so you kind of need to like center your witness.
Yeah, and the one tip I'm going to give on direct examination, and we'll see if Jamie or Kevin have any tips as well when we're on direct, is I find that you guys generally know your questions and answers so well that you just steamroll right on through them and you start talking a little fast and you start getting through it a little fast. And so when you have stuff memorized, you just got to remember sometimes just to pause, just to take a beat, slow yourself down a little bit, not too much, but a little bit. And then the other tip on direct examination, remember that you don't have all of the time in the world, so you don't want your witness to read verbatim their entire witness. Jamie, do you have any thoughts or tips on direct?
The only other one I would say is if you're the attorney, there's going to be times when you're going through the direct exam that you've practiced a million times with your witness, and suddenly it occurs to you, ooh, there's this new question that we didn't practice, but this would be really great if the witness gave this answer. But the witness has no idea that's coming. And so I would say 9 times out of 10, just don't do it. The only exception to that would be that you've practiced so many times and you know deep down the witness is going to know exactly how to answer this, but that's almost never going to happen. So it's going to occur to you, you're going to be tempted to do this, but my advice would be just stick to the script on direct. You're going to have a chance on cross to get really creative. And generally, we're going to talk about on cross, you want to ask questions you already know the answers to, but there will be times on cross when you can take some of those chances. But on direct, just it's about keeping your witness comfortable more so than the attorney staying comfortable, if that makes sense.
Yeah, and there is going to be a redirect portion one time, so that might be a time where you ask something you didn't necessarily plan for because you realize, oh, like on cross they were asked XYZ, so now I'm going to ask the follow-up. And again, you might get away with guiding them a little bit on what it is, but like Jamie said, we're stick to what you've already practiced and prepared and what you're comfortable with. Don't try to reinvent the wheel on the spot because it almost never works. Kevin, do you got anything to add to that?
I would say in general, keep it as conversational as possible. Um, yeah, because the because as Jessica has said, because you've practiced this so much, it becomes rote to y'all. But you have to remember to your scoring judges, this is brand new to them, and then they're not familiar with your presentation of the case as you are. So keep it conversational and keep it relaxed, and that will help you with the overall flow of your questions.
Yeah, and I'm going to say for the overwhelming majority of our judges, they will not have read anything about the case or know anything about the case. So
That's
everything they
true.
are learning about the case is from what you are presenting in your trial. So that's why we want to make sure we're being very deliberate about what we say, but also not speaking so fast that no one understands, not just buzzing through it, making sure that we're asking really deliberate and specific questions to elicit the information we need. Because that, as a scoring judge, lets me know that, like, okay, you actually know your case. I always think it's really fun, and I know Jamie and Kevin, I think Stacy hasn't had an opportunity to judge recently, but Jamie and Kevin, we generally judge multiple rounds throughout the year. And so I always find it interesting that the first weekend I judge to the last weekend I judge at state, I always am learning something new about the case
Yeah.
because I'm always hearing new facts, right? And so that's always fun for me, but it also is kind of like, oh, there's a lot of information that actually wasn't introduced at that first trial but it's also some of that's just your theory of the case. Sometimes that's just your case strategy that's based on what you decide you want to attack or not attack. So just remember that, like, when we're hearing you present it, that is our first time hearing it. Like, no one's, you know, I obviously have seen The Little Mermaid. I know about the facts of this particular case, but if you were presenting that case to me today, assume I know nothing about The Little Mermaid, that I'm hearing the names Ursula and Ariel for the first time, and you've got to convince me that Ursula is the good guy and Ariel doesn't want to do what she's supposed to ever, right? Just assume that that's the case, or vice versa. Ursula's a mean sea witch, and Ariel's just a poor little mermaid who got taken advantage of, and whatever. Okay, so now we're gonna roll into cross-examination. I'm gonna throw it back to Stacy.
Right. So I'm going to handle a couple slides and then I have to go. But I just want to say I have the utmost faith in all of y'all as advocates. And if you feel overwhelmed, just go back, look at these PowerPoints, and like hopefully that'll help you kind of like center. So cross-examination is the dramatic, fun, like what we all think of when we think of trial, right? And it is really fun. So what we want to do on cross-examination is, unlike before when the witness was the star and they got to talk and say what however they wanted to say it, this is the lawyer being the star. You are in control of the questions. You are painting, like your questions are what show the story. So that's why cross-examination can be so effective if you're prepared. So what you're looking for are bad facts for this witness or facts that help your side. So you want to discredit the witness. You want to discredit what they said, what they saw, could they see? You want to show limitations, weaknesses. So sometimes you'll deal with like, was this person able to see or hear? Or were they pretty far away? Did they have their glasses on? So impeaching is where you actually question the credibility of the truth of what the witness is saying. And you essentially try and prove that the opposite has been said or is true. So for the very important facts, you will want to impeach a witness, which is essentially proving that the opposite of what they said is true. So keep in mind, you're in control. You need to have a plan and have your points. So what points do you want to make? For example, if I was going to cross-examine Ariel, I would want to make the point that she heard Ursula say all these terms. She signed a scroll. She still got her legs. And so there's a finite amount of points that you want to make. And you want it to be clear for the jury to understand what you're getting at. So if you're going back and forth between things a lot just to like win, that's not as effective as actually winning the points you need to win. So asking closed questions that can only be answered with yes or no. I would highlight and circle this. This is for preparing for cross. This is how you can prepare, is make questions that are crafted correctly so that you lead the witness to say yes or no, and you will know what they're going to say because you can see their witness statement. So, for example, with Ariel, you'd say, you heard Ursula say, blah, blah, didn't you? Or isn't it true that you went to Ursula on your own volition? Yeah, I went to her myself. So what you're not doing is, by having these questions that can only be answered with yes or no, we call them closed questions, that means the witness can't explain. That means Ariel can't say, well, yeah, I mean, I knew that she wasn't great, but like she talked me into this contract. No, you went there on your own. But by forming the question in a way that says yes or no only, and sometimes you have to loop back with a tough witness and say, no, I asked you yes or no, did you sign the scroll? And she's going to say yes. So that avoids these like run-on kind of sentences that can just make it your point less effective. The other piece here is know when to stop. So sometimes when, the facts are going to be relatively balanced in your case that you get. And so you'll see there's all these points that we could just discredit this witness on. We could even prove that, something that has really nothing to do with the case. So maybe it's helpful to prove that they're a liar or to show bias, but is it just you fighting for the sake of fighting? So know when to stop, know when you've won your points that win your case, and sit down. So I think the best thing you can do is ask good questions, sit down when you're done.
I did it again.
Okay. So in this,
What the heck?
ooh,
Okay, sorry.
okay.
Sorry, this is the entire slide. I apologize, everybody.
So for example,
I think
we
this
want
just
to,
kind of restates what you've already said, Stacey,
yeah.
which is that the
So
goal of the
the,
plaintiff, we want to show that the defense is untrustworthy, they're uncredible, or solicit the facts that really help our case. And you signed that contract, didn't you, Ariel, right? And then the defense, you want to do the same thing. You want to attack their case. You want to get them to admit to facts that are unfavorable to their proof, things that disprove their case. Remembering that the plaintiff has the burden. So if you can disprove one of their elements, that's very helpful. And I don't think I necessarily talked about the burden of proof in this case. I think that got away from us somewhere. But the burden of proof in a civil case is preponderance of the evidence. What does that mean, Stacey?
that means that it has to be more likely than not that the plaintiff has met all of these elements. So it has to be more likely and not true.
Yeah.
So basically 51%.
Yeah. I mean, not even 51%. It's like a
Yep.
scintilla more than 50% one way or
Yes.
the
A
other,
hair
basically. So
more.
that a hair more, just a teeny tiny bit more. So anything you do that can attack the other side's case,
Mhm.
will help kind of bolster yours.
So
And so
sometimes sometimes your only cross points are going to be to discredit the witness. So like for an expert, you you could get into like maybe there will be points to say like was the test performed correctly or do you have the education, but more likely than not you're going to you're going to just want to discredit by saying you get paid to do this, you only testify on behalf of sea witches, don't you? Things like that. So sometimes that's your goal, do it well and be done. Let's see. So for cross-examining Ariel, for example, um, these are, for example, say she even drew you pictures in the air showing the kiss had to be true love, didn't she? So these are points and Ariel would have to say yes. Now she says, well, I don't know. Then you say, okay, did you see her draw a picture in the air? Ariel says, okay, yes. And so sometimes you do have to and that is your judgment, but if you spend the time getting your questions correctly formatted, you will be able to lead a effective cross.
yeah.
So not a good cross question is an example of a direct question. So the who, what, where, when, why, how. Why didn't you kiss Eric? That's just too much. That lets the witness tell their side of the story, and that is not the point of cross-exam. The cross-exam is your story gets told, the lawyers, through the questions.
I didn't remember to put all of my like effects on every single page, so but we're just trying to get through these a little bit
Yeah.
quicker so we can get to that Jeopardy for you guys. Let's sneeze. And so the same is kind of true of Ursula, isn't it true that you stole Ariel's voice? You took and you used Ariel's voice to seduce Eric. So, getting into those other elements of the case that Ursula actually interfered with Ariel's ability to perform her portion of the contract, kind of thing. You sent your two besties to stop them from kissing, didn't you? That kind of thing. I think Stacy's having to abandon us, so that's why I'm trying to just take over a little bit here. So those are just goals of cross exam, and those are some examples. So what we don't want to do is give the witness a chance to just kind of run off at the mouth and talk about whatever they want to talk about. This is an opportunity for you to, as the attorney, to present facts that they have to agree to, um, and go from there. And so we've got before we get into impeachment. Jamie, can you help me explain? It's like you've asked me a question, Jamie. You've asked me one of these questions. I'm Ariel. I hit the wrong button. So you asked me, uh, uh, I'm Ursula. So you're going to ask me this middle question.
Okay. And you used Ariel's voice to seduce Eric, correct?
Yes, but I did it because da, da, da. So what would you do in that situation if you were cross-examining me?
What I'm looking for is a yes or no answer to that question. And I already know the answer because I've read Ursula's fact statement. And I know the answer is yes. But of course, Ursula, as the witness, is going to want to come on and explain away because she knows it's a bad fact for her side of the case. So if Ursula's answer starts with yes, but I'm going to politely but firmly interrupt and go on to my next question generally. Unless I think the explanation could help in some way, but usually it's not going to. It's just going to be all I want is the yes.
Hmm.
And if the attorney objects and says, can my witness please answer their question? If it's cross-examination, most of the time the presiding judge is going to say, nope, let's move on because there's really no room for explanation there. If you don't get a chance to interrupt or you don't feel comfortable doing it, and Ursula tells her entire answer. Like, let's try it again, Jessica. So the question is, and you used Ariel's voice to seduce Eric, correct?
Yes, but I only did that because I was given an opportunity. I mean, like, he was really handsome, and I thought, oh my gosh, I actually think I want to be with Eric also. La 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 la, la, blah 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 blah, right? So I'm just gonna kind of run off at the mouth.
Okay, so then what I'm going to do is the questioning attorney. Okay, Ursula, redirecting you back to my question, you used Ariel's voice to seduce Eric, yes or no? So something like that, just to make sure that we're going back over it and you're looking just for a yes or no. And if she tries again to put all that extra information in, that's when I'm going to object and I'm going to say objection non-responsive or, just try to do something to keep things going.
And you can also with that objection non-responsive, you can just say objection non-responsive after the yes.
Yeah,
Because I asked a yes or no question, she went off at the mouth. And so that's a way to also help control a witness who likes to just start chaos. And it's a good tactic as a witness. If you're being cross-examined and they ask you an open-ended question, give an open-end, like answer that question. If they make the mistake of asking you why, launch into your life story behind why you did the thing. That's an excellent tactic because they should not have asked you that question.
right.
And that'll force them to have to control you, etc. But um, to the extent you're allowed to answer yes, but XYZ, you can absolutely do that. That's on the cross-examining attorney for not controlling the witness. So we want to also control our witness on cross-examination.
Yeah. Another tip for witnesses on cross. So the second question here, asking Ursula, and isn't it true that you stole Ariel's voice? If you're Ursula, you're on the stand, you could just say no. That's not true. And then the questioning attorney is going to get caught off guard and ask something like, well, what part of my question wasn't true? And then as Ursula, you can say, well, the use of the word stole is inappropriate in this circumstance. There was no thievery going on. She gave it to me. And so as a witness, that's a good way to really make sure you're listening to every word of the question. And if the questioning attorney wants you to agree to a question that you think is objectionable in some way, don't just agree as a witness. You can just say, no, that's not true. No, I don't agree. And then not only are you throwing that attorney off guard, but you're also eating into their time for cross examination by making them go back and explain what they actually want from you.
Yeah. And Kevin, I think there was a question in chat you were going to answer about
Yeah. So so with cross examination, this is kind of where we have seen teams use the tactic of having witnesses kind of launch into the narrative, all the time, to as a stalling tactic, and that's really disfavored. And in some cases, a judge, if a judge has to admonish, the witness multiple times that they're being non-responsive, that could be, that could lead to significant deductions in the witness's score. And so really the objection is non-responsive there. It's not, objection launch the narrative. It's really non-responsive. Um, but yes, so the idea of if you're the witness on the stand, the idea that now if you're asked a question that is open-ended, that's on the attorney for not asking the proper question. Your job as the witness in that case is to answer the question that is answer the question that's asked. Now, if you're the attorney on that, that's why asking those closed-ended questions will help you avoid the situation where the witness can be invited to go off on a tangent. So I
Yes.
yeah.
Great answer, Kevin. Okay, so we're talking about impeachment just a little bit. I'm not gonna sit on this for a long time. When we talk about impeachment, it means that we think the witness didn't answer correctly. You really should not be impeaching your own witnesses. I'm just gonna put that out there. I've seen that happen a couple of times. I'm like, don't attack the credibility of your own witness if you can avoid it. There's other ways to get them to correct their answers without impeaching them. On cross-examination, my main tip for impeachment is make sure it's actually an important fact. Because if you spend a lot of time trying to impeach them on something that's not crucial to the case, you're just spending your own time that you don't necessarily have. Um, and in this, we have kind of a basic setup for how to do it. So go back and look at this slide if you want to know how to impeach a witness. You can have a little script ready to do so um, with some tips or trips, but tricks. But that's the main thing I would say is just don't try to spend a lot of time doing it. If you're not comfortable impeaching a witness, just don't because if you're trying to do it for the very first time in your trial, it's going to take a lot longer than you expect it will. So, introducing exhibits. Um, if an exhibit is stipulated in the case, you don't have to lay a foundation. You can just offer it. Sometimes in the past, we've had, oh, exhibit 3 is authentic and a witness just has to identify it. So I think there was like a map or something. So it was like, hey, Kevin, this is a map of Dallas, right? And Kevin's like, yep, that's a map of Dallas. I live there. I know what that is. And you're like, okay, great. I'm going to offer exhibit 3 into evidence at this time. And that's all you have to do. Um, Witness statements are not exhibits. They cannot be offered as exhibits. They can be used for impeachment, but that's not the same thing. We're not offering them into the exhibits. The only things we can use as exhibits are the ones in your case packet that are labeled and identified as exhibits and already numbered for you.
And we did get a question about this earlier, and no, the answer is no. You cannot blow up or enlarge the exhibits. The exhibits are what they are.
Correct. Okay, and so our basic exhibit foundation, again, I'm going to kind of go through this a little bit quickly because we want to get to the Jeopardy, but basic foundation is just you're identifying what it is, or the witness is going to identify what it is. How do they know what it is? Is it fair, accurate, etc.? Has it been altered or edited? And then you're going to offer it into evidence. Once it is admitted, then you can ask to publish it. You cannot publish it if it is not admitted. When they offer it into evidence, that is the opportunity for the other side to object to the lack of foundation or to any other rules of evidence, such as this is hearsay or this is whatever. I don't even know off the top of my head what those those objections would be, but that's when you would do that. As the presiding judge, if you offer an exhibit, I generally say, counsel, do you have any objections to this? So that I kind of solicit that. Some judges won't, and so then you would just stand and say, Your Honor, we object to admitting exhibit 4 because of the following reasons, right? Um, for objections to exhibits, this is really important. This is something you want to prepare in advance, is you want to review those exhibits, figure out all the objections that can be made. So that way, if you're the person putting it in, you can anticipate what objections they may make, and you're prepared to respond to those objections.
So Jessica, I think we got a question in the chat about when attorneys are able to object.
I mean, I think the answer is really at any time, but if we're talking about an exhibit specifically, if you object prematurely, as the judge, am going to say, well, they haven't finished their foundation yet. So once they try to offer it into evidence, that would be the time to object. Or if it hasn't been admitted into evidence and they're trying to read the exhibit out loud, that would be a good time to object because you would say, Your Honor, that exhibit has not been admitted into evidence. If one side has already admitted an exhibit, does the other side not have to? No, you don't have to. Once it's admitted for all purposes. The other side does not have to introduce it as an exhibit.
And I to chime in here, sometimes the teams will agree before will agree before trial to to use certain exhibits in opening. um that there is no prohibition against that. So if assuming and you know that sort of thing. And as far as objections during opening, you can't do that. How to handle that is after opening, you would say, Your Honor, if I were able to object, I would have objected to blah 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 blah. And that's how you would handle an objection during opening.
Yeah. And so I will also say if the only exhibit you have prepared to put in example is exhibit 6 and you're on defense and the other side puts it in during their plaintiff presentation, go ahead and do your foundation if you want to, if you just want to prove to the judge that you know how to do it, but you don't have to. It does take up time that you maybe just don't necessarily have. But no one's gonna stop you and say, no, that's already in. Um, Objections, and then I really just have, I keep going the wrong way. I'm so sorry. Um, the basic format, we're not going to go over specific ones, but the basic format is just you're going to stand as calmly as possible. You're going to say objection, hearsay. Here's why it's hearsay, right? You don't want to yell. You don't want to shout. You don't want to be disruptive in a way that's not helpful. Obviously, objections are disruptive. You're literally interrupting the other side, but you don't want to do it in a way that just seems obnoxious, I guess is what I would say. We will usually ask for responses to objections from the other side, but I'm going to tell you we're usually only going to do that once or twice. If you're making the same objections each time, I may just start ruling on your objection because I already know, Kevin keeps objecting with the same objection every time, and Jamie has given me her very thorough response to it, and they both argued it one time. I might just start ruling on Kevin's objection so we can just keep kind of moving through the trial because, okay, great. I know these two know the basis of the, you know, excited utterance hearsay objection, right? Like I know that they both know that. They know the exception. They know all the details of that. Okay, great. I'm not going to keep listening to them. No offense. We're going to try to move through the trial. So don't be alarmed if a judge does that, if they just start ruling on your objections. Um, it doesn't it doesn't really affect you one way or the other, generally speaking. So you would just stand and say objection, speculation. The witness has no direct knowledge of what's being asked. And the response can be, no, the witness actually saw what was happening. It's not speculation to tell the jury their personal knowledge. And if you don't have a response, just make one up. Just figure something out on the spot.
Yeah, the exception to that would be if you ask a question and while you're asking it, you're like, oh no, this was kind of a bad question. It doesn't make any sense. And the other side objects, like objection vague, objection ambiguous. As the questioning attorney, you can say, I'll rephrase because you already know it's a bad question. And that gives you a chance to just rephrase the question. So you don't have to have a response to why it isn't vague.
I mean, vagueness is actually not a legal objection either, I would say. So you could just say that, well, it wasn't a legal objection, but I'll agree to rephrase because I agree
Yeah.
that I messed up. Um, so, just come up with something. You're like, ooh, that sounds like a really good objection. You could always just say, oh, I'll rephrase it. Let me ask that question a different way. Or, you know, if they say objection hearsay, no, it's not hearsay. Just say that. Just say it's not hearsay. Just at least say that as your response. Um,
I
so with
I Oh, so sorry. Just jump in real quick. So last year, I observed a trial where one side seemed to take every objection personally. Don't do that. Yeah, don't take objections personally. It just think of it as you're working a problem, and you just take it as it comes. But yeah, yeah, and if you're the one making the objections, don't make it come across like you're personally attacking the other side. Just make your objection, state it calmly and plainly, and address it and move on.
Yeah, and I would just also kind of keep the mindset that we have attorneys keep in trial. I don't make objections to be personal. I do it for record purposes so that if something goes wrong in my trial, like I've done all the objections I need to make. Like it has nothing to do with the other side. It's me trying to make my record. And so that's how you can also approach it. You're never attacking the other side for what they're doing generally, unless it's something like Your Honor, they're badgering the witness. They're being really inappropriate. And again, witnesses don't talk during objections. You're just going to lose points if we have to tell you to stop talking. So we're going to talk about leading questions. There's hearsay. What I will say about leading questions, Jamie, if you want to go ahead and get your Jeopardy set up, you can. Leading questions. Let me say this. Yes or no questions are not leading questions. Leading questions generally are yes or no. But if I ask Kevin, was the car green? Kevin is free to answer yes or no. I've not given him the answer. I've not suggested what he needs to say. However, I say the car was green, wasn't it, Kevin? I have now suggested to him what I want him to say. So that is the difference between a yes or no question generally and a leading question. A leading question suggests the answer, and that's what we want to do on cross-examination is we want to lead our witnesses. We want to tell them what the answer to that question is because again, that's our time to shine. And we're just getting them to agree to those details. So we'll have a little bit of time at the end. If we want to ask some more questions, we'd be happy to answer those. But for now, I'm going to let Jamie take over with some Jeopardy.
All right, so we'll go through this pretty quickly, but it's an opportunity for you all to have a little bit of competition at the end of this. So the way we'll do this, and first of all, can somebody give me a thumbs up if they can see my screen with the board? Okay, thank you. So we're going to form 3 teams, and I think the easiest way to do that will be if your first name starts with between the letters A and G, you're team 1. If you're between H and M, you're team 2. And if you're between N and Z, you're team 3. If you're with a big group of people in one school, then just use the first letter of your school, and that'll be the team that you're going on. All right, so what I'm going to do is I'm going to start this. We're just going to play one round. And I'm going to ask Kevin, if you don't mind, to monitor the chat and figure out who is going to be the first person who comes in with the answer, and then we'll go with that person's answer.
We'll go with the first letter of your first name.
Yes, thank you. Okay, so I'm just going to start with the very first question here, and then whoever answers questions correctly will get to select the next question that they want to go for. So we're going to start with trial procedures for 100. The title that the judge must always be addressed with.
See, Grace Academy, Your Honor, is the correct answer. Grace Academy, good job. Team G.
Okay. What is Your Honor is the correct answer. All right, Grace Academy, you can pick the next question.
Trial procedures for 500.
Okay.
Ooh.
The number of minutes you have to ask direct questions, and that's per witness. Or not per witness, I'm sorry, it's for all your side's witnesses.
Renee Carre.
Okay. And that is 25, that is correct. And this is actually incorrect because it's from a different state's mock trial, but 25 is the correct answer for us.
Yeah, and we're not going to make people say like what is or how it.
Right.
Like, yeah, you don't have to frame it as a part of the question. Just tell us the answer. We're fine.
Okay, Renee, you can pick the next category.
Objections for 500.
500, all right. The objection made when a witness theorizes as to what possibly could have happened.
Brooke Hall.
All right, and what did Brooke say?
Speculation.
That is correct. What is speculation? Because the witness doesn't actually know what happened, so by definition, they have to be speculating for them to provide any kind of answer. It doesn't have to be true. All right.
Brooke. Brooke, where do you want to go? Extra for 500.
Okay. The whole procedure that one needs to go through in order for a document to be submitted into evidence. And I don't know what that last part means, but let's go through and I'm going to ask somebody to unmute to answer this question. So whoever wants to do that, just put in the chat unmute. All right. And if nobody wants to do that, then I will. Nobody is brave enough. That might be true. It's a little bit complicated. Once you do it a few times, it's not complicated anymore. So it's just the kind of thing that you have to do a couple times. Kevin or Jessica, did one of you want to take this?
Jessica,
We
you're the trial attorney. I'll let you do this.
Wow. Are we talking about laying a foundation?
Yes.
I wasn't actually reading the questions. I was like, oh no, let me go read it real quick. Um, and I think Renee answered that one first again in the chat. So Renee, if you could give us a category, if we could go back to the categories, Jamie.
Yeah, so I think Renee had said foundation. That's definitely the first thing you have to do. And I just want to make sure we're all
Ooh,
set with the procedure that needs to happen once you do have the foundations.
asked to admit it.
Yes, that is
There
really,
we go.
really important. Is you need to make sure that you lay the foundation and the witness recognizes the document, confirms that it's the type of document that it appears to be. And then once you finish laying that foundation, then the next question you need to ask the judge is, I move to admit exhibit 2, exhibit 3, whatever it is, and make sure you do that next step because otherwise you've laid the foundation for a document that is not in evidence. So
Yeah,
you
so
just want to make sure you do that.
in my mind, admitting it is part of the foundation. So like I don't even think of them as two separate things. My foundation is not complete until I offer to admit it. And so that's how I remember to do it is that and I'll be honest, even as a trial attorney, I put that in my script. I have like my exhibit, I have my foundation, and then in bold and highlighted, I will say offer into
Yes.
evidence.
People forget, and it's fine. Like there's a lot going on, but that's just something you should definitely, I like having it bolded and highlighted. Just remember to enter it into evidence.
Yep.
Okay, Renee, I think had our last answer. So Renee, you can pick the next one.
We already did extra for 500, I think, Jamie.
Oh yeah, it just didn't for some reason go through. I think I needed to do that. Okay.
There we go. Renee, can you pick a objections continued 500?
Okay. The exceptions to the hearsay rule are, and you must state all four. This is really, really advanced. Instead, I'm going to change it a little bit and I'm going to ask, name four objections that are permissible under the mock trial rules. So you're objecting to questions. Name four objections that you
Or
can.
or just tell me one exception to the hearsay rule. Like give me
Okay. So
one.
speculation, excited utterance, hearsay, another excited utterance, hearsay, speculation, excited utterance, and something.
Deathbed is, I think, the direction this question is maybe going.
But then here's a question, what's an excited utterance?
Valid question.
So an excited utterance is an exception to hearsay, and it's because when someone says they see a dead body and they say, oh my gosh, it's a dead body, that's an example of an excited utterance. And that is considered to not be hearsay because it is I'm not even sure I can explain this quite right, but it is an exception to hearsay.
I
So
would
So,
say I would say it's because it's generally not thought out. No one stopped to think about what this answer is. Like you hear an explosion and you go, "Oh my God!" Like that's an excited utterance. Like I
you're
I was just reacting to a thing. I didn't plan for it. I wasn't responding to a question. There's not been any opportunity for me to think about what my answer or how I would respond would be. Kevin,
And
you
be
had something to say?
and I was gonna say because you're not thinking about it, because it's an automatic response, there's less likelihood for you to falsify it.
Yeah.
Yeah.
And that's why it's an exception to the hearsay rule.
Yeah.
Yeah.
I
So,
just want to look
yeah,
in the chat for a couple of other objections that were here, just so we can spend a little more time talking about
I
objections.
think it was all like the
Um,
same.
what's
Kinda.
that?
I think they were generally, it was like speculation, excited utterance, hearsay, excited utterance, leading questions are examples of objections can be made. Um, Someone said offered before police Mirandize. Um,
In a criminal case, that could be an objection because, and I'm not going to go too into depth about this because we're not doing a criminal case this year, but there could be an objection to all evidence that comes in if the Miranda rights were not read properly. So, but that's really, really advanced, and we're not talking about that in this
yeah,
case, but I think that is technically correct.
I would say an exception to hearsay that maybe does apply to what they're saying is an opposing party statement would be an exception to hearsay.
Yeah. And then here are some of the exceptions to the hearsay rule. We've already talked about excited utterance, which I think everybody was very excited about. That came up in the chat a lot. Admission against interest is if the witness says something that is so clearly bad for them, then there's no way it was hearsay because they wouldn't have said it on purpose. They wouldn't have said it in an effort to protect themselves. State of mind, when a witness is just talking about the state of mind they were in when a certain event happened, and they're saying, I was really, really angry at that time, that's not hearsay. I mean, that's just talking about how you were feeling at that time. Business records, exception to hearsay is for documents, and a document that might be like a doctor's record or something like that. And there might be a hearsay objection to it, but if you can lay the foundation that this record is kept in the ordinary course of the doctor's business, then that can be an exception to the hearsay rule as well.
Cool. I was calling on Jason Dalrymple to pick the next category, but I think they maybe ran away. Oh, they ran back. Okay.
Okay.
They have their monitor, their camera on, so I can see that they're there. They get to pick the next question. Objections for 100.
Right. The time when an attorney should stand up to make an objection.
Everyone's saying anytime.
Okay, so ideally, the time to stand up is after you hear the attorney's question. Realistically, sometimes the attorney witness banter is going so fast that you cannot get to your feet before the witness starts answering. And that's okay. You can still stand up and object, even if the witness has started their answer. You just have to be sure that you don't wait until like the witness is all finished just because you're trying to be polite or something like
Yeah.
that.
Victor Gal gave the big brain answer of when something is objectionable is
Well,
when you would stand up and make an objection. And I love that answer. But yeah, generally you want to object when it's happening, not 5 questions later, because it's too late. If they've asked a bad question and they got an answer and you didn't object, it is too late,
yep.
generally speaking.
But I actually do want to go back to Victor's answer for a second, which is when something is objectionable, because, as presiding judges, the time stops when objections are being heard. And so there are some trials that last an hour and a half, and there are some trials that last 3 hours in mock trial. And the reason they can go on forever and ever is because of objections. And like Jessica was saying earlier, if an objection has been ruled on and the attorney keeps making the same objection and nothing is progressing, then it really does come across as wasting time because it's already been ruled on. Don't keep trying it, try something different. In my philosophy is object, I agree, object when something is objectionable, but also think about, is this going to help my case? Like, does this matter? Or am I just objecting for the sake of objecting? There can be good reasons to do that. Like if you want to interrupt the flow of the questioning between the attorney and the witness, but you don't always want to do that if you start seeing the presiding judge looking annoyed. You should definitely be looking at them for their body language. And if you're just objecting on every single question, that is, even if you have good objections, that's not always the best strategy. So it's just something to talk about with your team and your coach as you're preparing.
And as a reminder, we don't object during openings. And I don't think we can do it in closing either. I would just say don't even worry about them for opening or closing for mock trial purposes. Focus on what you're doing in your opening or closing. You're listening to what they're saying so that you can make notes on things you want to address in your portion. You're not listening for objection purposes at that time. So I would just not even worry about that.
Okay, what is it? The time an objectionable circumstance has occurred?
Oh, Victor was right.
Or
Ding, ding, ding.
okay, and because we talk so much about it, I'm going to go back to Victor for the next clue. Trial procedures for 400. The side of the courtroom that the defendant sits on.
Ooh, all right, there we go, Natalie. Natalie Ornelas got it. The opposite side from the jury box. Everyone's saying left, but some courtrooms, the jury box is on the left. So the answer is opposite from the jury box because the uh, plaintiff or prosecution is going to sit closest to the jury. So good job, Natalie. So Natalie, if you want to go ahead and give us
And the answer
this
says
says
left.
this is left side. I will say some states are very rigid about how they set up their courtrooms, and that's why in Texas it is all over the place.
Yep.
So Natalie, if you want to go ahead and give us your next selection. I will pick one if you do not. Trial procedures for 300.
When can recross questions be asked?
Victor, go after redirect.
That's right. So yeah, there's 4 rounds for every witness. There's direct, there's cross, there's redirect, there's recross, and that is it. So there's no redirect, there's no recross. There's just those 4 rounds. Now, another question is, do you have to do a redirect?
No.
Can you do a recross if the other side did not do a redirect?
No, says Jason Dalrymple. Good job.
That's correct. So the only way you can get to a cross is if the other side does a redirect. Otherwise, it's just done after cross.
Sorry, I could see them cheering for themselves. It was cute. I liked it. So, Victor, go ahead and call us out. Technically, by the way, yes, a recross happens after cross, but more specifically, it has to happen after the redirect to clarify what happened in chat. So, Victor, if you could go ahead and give us another category there. Objections for 400. And we're going to pause for a second, Jamie. Someone asked, what does recross mean? We've talked about direct and cross. So direct is when you ask your open-ended questions. The other side gets to cross-examine and ask their more specific leading questions. Redirect is where you're going to come back and say, clean up maybe something that was answered on cross that we didn't love the answer to, or that maybe we just want to reiterate something. And then recross would be an opportunity to ask additional leading questions. You don't have to do those. You can just say, no, I did my cross-examination questions. Repeating yourself on recross doesn't do anything.
And for some, maybe for some of our newer teams, if you are going to do if you're going to redirect after a cross, the questions on redirect need to be within the scope of the questions that were asked on cross. Otherwise, they're outside the scope and are subject to being objected to.
Right. That's really important too. Like if the entire cross-examination is about Ariel had a singing career before her voice was taken, and the singing career died because of this. And then you come back on redirect and you ask Ariel, so what's your favorite color? That's not within the scope of the cross, and so it would be objectionable, and the other side could then object to being outside the scope of cross. All right, let's go on to objections for 400. A question that requires the witness to make up information is objectionable as what?
Invention of facts. Okay,
Yeah,
so that is a violation of the rules of mock trial, so don't do that. So we don't make up information. You could definitely object to that if you think they are making up information, but generally we're not going to be able to do that.
yeah. So that would be a penalty, right?
Yeah.
If somebody just comes in and just starts making stuff up about,
Hmm.
well, before Ariel began her singing career, she was a truck driver, and that should come into consideration, but that's not in anybody's fact statements. Then that's just something that is a penalty, and you would have a point taken away for that.
Correct. Please do not make up facts that are not in the witness statements.
All right, I think we've got time for maybe one more, and then we'll open up just to questions generally. So I am just going to pick one because we haven't done rules of evidence witness examination at all. So let's see what happens when we do that. The rule that prevents one from asking cross questions related to matters that did not come up in direct examination. So we don't need the rule number or anything like that. And this is something that we just talked about. But let's just make it a yes/no question. Can you ask cross questions related to matters that did not come up in direct examination?
Oh, everybody's saying no, Jamie.
Hey. All
I
right.
think actually I disagree. I don't think that's actually prohibited in our mock trial rules. I think we're actually allowed to cross the first time, the very first time you cross. You can cross on facts that have not been talked about in direct. You cannot recross if it was not brought up in redirect. But that would happen because sometimes they don't want to, they just don't try, they try not, and actually even in the rules of evidence for Texas in general, they may just not talk about something on direct they don't want the jury to know about, and you are permitted to put that in front of the jury on cross. But redirect, recross, I disagree with the answer is what I'm saying. So you can tell me if I'm wrong, Jamie. You can tell me, no, actually, Jessica, you don't follow the rules of evidence.
Yeah, I think the point of cross in Texas mock trial is limited to the scope of the witness's witness statement and their testimony on direct. So you can't ask a question on cross that either wasn't covered in direct or isn't part of the witness's statement. Like you couldn't ask Ariel, oh, so you were a truck driver before and you're just making stuff up out of thin air. Like that kind of thing you couldn't do. But yeah, you just have to make sure that what you're asking on cross is based in something that the witness is actually able to answer.
Yeah,
Otherwise, yeah.
of course. I'm just thinking of the example of a couple years ago when we had that witness who was making like millions of dollars for their testimony. And I saw people on direct just not talk about the compensation at all. The cross was absolutely permitted to cross-examine them about their compensation and what they were getting in exchange for that. And maybe it's because technically it was in the scope, maybe something was sort of alleged or whatever, but um people are agreeing with me in the chat is all I'm going to say. And so I would just say, but then when we get into the redirect and recross, it does need to be within the scope of what the person before you said for sure. But on that cross, you're permitted to get into stuff that maybe the other side because otherwise people would just not talk about the bad
Right.
facts and you could never get it in. So that's why I'm saying yes. And lots of people are agreeing with me in the chat. So we're just gonna go with what the chat says.
Yeah, so it actually ended up being a really useful question to cover because there was a lot to talk about there. And just to make sure everyone is on the same page with this, When you're directing a witness, you can ask whatever you want as long as it's within the scope of their witness statement. And so the reason it has to be within the scope of their witness statement is so that they can answer, because otherwise you're just asking stuff they would have to make up information from. Same thing with cross-examination, scope of their witness statement, and anything that was covered during direct. But then when you get to redirect, it has to be limited to the scope of the cross-examination. When you get to recross, it has to be limited to the scope of the redirect.
Somebody dropped some knowledge in the chat, which of course I knew somebody would know the rules better than me, which is that Rule 611B agrees with me.
Oh, good.
So I'm gonna need Rebecca Mitchell to go to court with me going forward so that they can cite to the rules for me so that I don't have to do that anymore. So we're getting kind of to the close of our time, but we're happy to answer questions. If people have more questions, please put them in the chat. We'll address as many questions as we can. Like we said, this is recorded. This is going to be put up on our YouTube page with all of our other videos, with all of our breakout sessions that we did before. And so, we'll put it all out there for you guys to see so you can watch it again. Questions about the rules of the competition, those can be directed at Melissa. If there's enough confusion, she'll send out like kind of a statewide clarification about a rule. And then, of course, I'll take that and clarify it in the rules going forward. The presentations, I usually save them as PDFs, and Melissa will distribute those as well to everybody so that people can have the PDFs. What is the YouTube channel name is a great question. Let me open the thing I have that has the link so I can drop it to you guys.
And while Jessica's doing that, best of luck to everybody. It's always very exciting at this point. You've got a lot of work ahead of you, but also the really fun part when you come to court and we get to see you all in person. And yeah, here's hoping it's going to be a really great year for everyone and best of luck.
All right, I've dropped the link in the chat to the YouTubes for Texas High School Mock Trial to where all of our videos are. We've got all of our previous presentations there. There's also a bunch of state rounds state championship rounds that are on there. So you can always watch those for tips or tricks or advice to see what students do and how they present stuff. And yeah, good luck to everybody. If you're in Houston, I'll see you on February 7th.
Yeah, I'm enjoying all the talking smack that's already happening in the chat. So we will keep it going. All right, thanks all.
Bye, everybody.